So very good evening everyone. So today we are going to start with revision on some core areas of the economic laws, namely, as I already said, the concepts regarding Sebi. So first we start with the Sebi Act, because more requests came to me to start with the Sebi. So I don't know why they are feeling very difficult about this chapter, though it is not, but still okay, no issue. We will be starting with the Sebi Act first. Once we complete the Sebi Act, next thing I will be starting with Arbitration and Conciliation. Once after that, Sebi LODR, PMLA. Anyway, this week, max by Wednesday or by Thursday, we will be having one IBC session and one FCRA session, including the amended provisions. I don't want to merge those two chapters with this particular lecture. This is only completely a revision lecture, revision on 4 core areas of our economic laws, which scores us 20 marks in examination, pakka. Okay, Sebi, you can expect in the examination Sebi topic 6 to 8 marks in examination you can expect from this, and a 3 marks to 2 marks you can expect from LODR, or max 4 marks you can expect. So both put together it's a 10 to 12 marks area. Okay, arbitration will be a 4 marks area, 16 pakka question. After that, after arbitration 3 chapters, a PMLA is there, that will be covering out a sure area of 5 marks. PMLA I will be taking at the last. I will start with the FEMA revision first, the round the clock, all the concepts of FEMA in a simplified summary. Let us complete of the FEMA as well. So as much as possible in the time that is available, we will be covering out these areas. Why PMLA I kept at the last? Let me tell you the reason. Very recently, 2 months, 3 months back, PMLA full revision lecture was there already in the channel. So again making the same lecture, I don't think that is a wise decision to take. So let us complete off those lectures which are not already available on the channel. Okay, anyway, those who participated through the live session, for you definitely the benefit will pass. Let us first complete of the concepts what are already promised to you. So Sebi concept is the first thing that we are going to start with. Once after Sebi, we will start with arbitration. First let us complete those two sets we will complete. So let's start with our lecture. And moreover, a session was not there, full day session is not there, because I was not well. So I was unwell in the last 3-4 days because of continuous sessions and classes. So therefore I am putting a small length sessions like 3.5 hours like that. So no other reason. But by Wednesday I will be becoming okay. And Thursday, Wednesday we will be having sessions on Insolvency Code as well as on Foreign Contribution Regulation Act, along with all the amendments applicable. Okay, if you listen at this point of time, just 1 month after exams will be there, you will be perfectly presenting the answers. Okay, so time is less now, you will immediately listen and you will write in the examinations. So please concentrate. Let's start with the topic. So we are going to start with our first topic called as Sebi Act, Securities and Exchange Board of India Act 1992. See here. So when we ask about the Sebi Act, so Sebi Act is a chapter which will be having mainly, it will be having 3 different parts. First one will be the basics. Second one will be the judiciary, second one. And third one will be the administration of capital markets. These are the 3 areas under which the Sebi chapter is divided: basics, judiciary and administration. In these 3, from the examinations point of view, which will be asked more number of times, if that be the question, judiciary will be the highest times that is being tested. Okay, judiciary includes many things inside, punishments, penalties, all these things will be there. Okay, easy to understand and remember those areas. So those are only highly asked. Highly asked does not mean that will be only tested. If there are 10 questions that come, 5 questions will come from judiciary, remaining 5 will be shared by basics and administration. Basics will be 1 or 2 questions in every 10 attempts. Administration 3 questions in every 10 attempts, judiciary 5 times in every 10. So like that we can understand. Okay, that means everything has its own chance to come, but when it comes to ABC analysis, that is the thing. But we are going to start with normally. That means first one will be the basics, next one will be the judiciary, and third one will be the administration of SEBI and capital markets. Okay, so let's start. Securities and Exchange Board of India Act 1992. So the first one, every act will have a clear preamble. The preamble to this SEBI Act. So first one, an act to provide for establishment of a board. So everyone generally, whenever we call what is the preamble of SEBI, immediately they will tell SEBI preamble is protection of investor. SEBI can't protect investors if there is no channel to go. Simply to tell, yes, SEBI will save investors. In what avataram it has to come? It has to come in an avatar called as a board. Board means here SEBI short form will be called as a board. Whenever in this chapter, if I call board, board does not mean board of directors. Board means a SEBI. Okay. So first thing, the intention of SEBI, the preamble of SEBI is not protection of investors. It is to establish a board. Through that board, I will do this. Okay. So try to understand SEBI Act. Both are different. SEBI is a entity. SEBI Act is a legislation. What is the objective of this legislation? To establish a SEBI. After establishing SEBI, what is the objective of SEBI? That is the objective of SEBI, protection of investors. I think you can understand now how to write an exam. So preamble of the act, SEBI Act, what is the preamble? Immediately, protection of investors is not the objective of SEBI Act. No, nowhere it was said like that. SEBI preamble is to establish a SEBI entity. That SEBI entity's intention is to protect the investor interests, development of security market, and incidental to the investor protection, incidental to the development of securities market. Okay, conducting advertisement campaigns, conducting the promotional campaigns, okay, establishment of IEPF, disbursement of losses caused to investors, okay, punishing the persons who done the frauds in the stock markets. All these things will come under protection of investors, and related matters will be there, and the development of securities market. These are the two things. Okay, so I repeat, first thing, the preamble of SEBI Act is not protection of investors. Preamble of SEBI is to establish SEBI. That SEBI's intention is to protect interests of investors, development of security market, and matters incidental thereto. This is the basic idea behind SEBI. So hope up to here everyone understood the concept clearly. Okay, so up to here everyone understood the concept clearly. Next one. Next issue. Short title, extent and commencement. Sir, what is this name of the act? SEBI Act. Applicable to whole of India. Commencement 30th January 1992. Next one. Definitions. What is a board? Board means SEBI. Completed. Collective investment scheme. I will keep it on hold. We will be discussing this separately today in section number 11. Okay. Most of the students are having confusion in understanding what is a collective investment scheme. Today we are going to demystify all those things. All the misclarities what you have, we are going to burst up today. So what are all the wrongs we understand till date about the collective investment scheme, how they actually works, how they operate in the original market scenario? We will see that in the today's session, but after some time. Next, member. Whenever I call a member of SEBI, not company members. Board is not board of directors. Member is not company member. Shareholders la member illa. SEBI la member. And includes chairman. Means what? Whenever in this act I use the word member, member not only mean members and chairman. Everyone will be included. Okay. Next. Establishment and incorporation of the board. Okay. First, who established SEBI? Central government. With a name? SEBI. What are the features? It's like a company. It's an entity in a Body corporate, perpetual common seal, it can hold its own property, sell its own property, it can enter into contracts in its own name, capacity to sue, capacity to be sued. Simply these are all corporate features. That's why SEBI is a classic example of body corporate. What it is, sir? Body corporate. Sir, can anyone in the session who are participating over live, small question for you, what is a body corporate? What is a body corporate? What is a body corporate? I want your participation, sir, please. What is a body corporate? One person, Ishwari Priya, said established under any act. Okay. Mohit said limited liability. Okay. Company, LLP, entity. Okay. Special act. Okay. Venkat has given answer as a company, which continues irrespective of individuals. Okay. Okay. Karthik has given body corporate means a CB means what, Karthik? J Karthik has given answer CB. CB means foreign company plus other act. Okay. Corporate entity which have legal existence. Okay. An entity established under special act, legal existence. Okay. Sriram has given answer as legal existence. Sai Avinash, legal existence. Nivedita Desai, established under special act. Okay. Entity having common seal. Okay. Okay. Sorry. Okay. Very good. So everyone have their own answer on this. Some people will tell it will be having special act existence, or some people are telling that it is having. Okay. Sir, anyway, let me now explain what really a body corporate means. Sir, this is not for any general knowledge sake. We are not here to do any general knowledge business. We don't have even that much time, but still it will help also for your Companies Act. Whenever the word body corporate comes in loans to directors section or in the 186 investments by the company, you should get a clarity on what do you mean by a body corporate. Anyway, occasion came na, let me explain just in 2 minutes. See here, sir. First, artificial existence, limited liability, perpetual succession. Okay, perpetual succession, capacity to sue and to be sued. Next one, capacity to hold properties, capacity to enter into its own contracts, separate legal existence. Okay, separate legal existence. All these are called as corporate features. Remember, all these are called as what, sir? Corporate features. We call all these as corporate features. So remember this word, corporate features. All these list: artificial existence, limited liability, perpetual succession, capacity to sue and to be sued, holding its own properties, holding its own contracts, separate legal existence, for that case the common seal. All these will be called as a corporate features. Okay, now listen carefully. So I am rubbing this. All these will be mounted to corporate features. A body, I'm talking about an artificial body, not human body. I'm talking about artificial bodies, entity to call very simply. Okay, so a body having corporate features. What are corporate features? List we have written now. A body having corporate features. Obviously it will not be a human body because you don't have perpetual succession concept. We will not be there forever. Okay, sometime or the other we will leave and we will go. So we don't have that perpetual succession concept. So therefore this is not for human beings, understood in the first instance. So it's a body having a corporate feature incorporated under Companies Act. We call it a company. Okay, incorporated under Companies Act, we call it a company. There is a body having corporate features incorporated under any act, we call it as a body having corporate features called as body corporate. Called as body corporate. It's a body having corporate features will be called as a body corporate. From this, what you need to understand, I have written any act. This act can be Companies Act. This act can be other than Companies Act. Anything can come. That means it can be even other than Companies Act. That means every company is a body corporate, but every body corporate need not be only a company. Body corporate can even have LLP. Let us check the situation now. LLP is a body having corporate features incorporated under LLP Act. It is a body corporate but not a company. State Bank of India having corporate features incorporated under SBI Act. It's a body corporate, not a company. Clear? I said any act. I said any act. I said any act. Any act can also be US Companies Act, UK Companies Act, any act. That's why foreign companies will be body corporates. So this is the logic. So I think everyone at least understood what is a body corporate now. Everyone in the class understood what is a body corporate? Everyone? So this is the whole idea behind a body corporate, sir. So Sebi is having all the corporate features, therefore it is also called as a body corporate. As simple as that. Okay. So let's continue. Next issue. Next issue. See here. So establishment, CG will establish where name Sebi, having corporate features, head office in Mumbai, branch in any other place, wherever central government decided. It's there in Chennai, it's there in Hyderabad, it's there in Bangalore, it is also there in Vijayawada. Okay, it is also there in Vijayawada. So every place, wherever they deem fit, they thought that some companies are there or will be coming, immediately they will establish Sebi there. It depends on the central government's intention. Okay, now next, management of the board. Okay, listen, this is very, very important. Board is there, management will be there. There is a company will be having board of directors and shareholders. Yes or no? Now this company is a board of directors, shareholder. Now we are talking about a Sebi being a body corporate. It is having board of directors and shareholders. No, we call them as board of members. We don't call board of directors, we call board of members. We don't call shareholder, we will be called as authority. This is the central government. Central government hold full rights on Sebi. Okay, so BOM means what? Board of members. Here directors we will not call them, members we will call. Okay, now who will be there? One chairman will be there. So totally 9 is the number. You remember that. One chairman, 2 members, one from Ministry of Finance, one from Ministry of Corporate Affairs should come. 1 member from RBI and 5 other members should come. At least 3 in this 5 must be whole time members. Must be whole time member. That means 2 part-time members are tolerated. I repeat, 1 chairman, 2 members, 1 from the Finance Ministry, 1 from the Corporate Ministry, 1 from RBI, and 5 other members. In that 3 must be whole time, 2 may be part-time. Okay, so this is the idea behind the quant. Clear? So therefore, sir, exactly 9 should be there. Yes, 9 is apparently a confirmed amount which you should have at all the times. This is like minimum number of directors in a company. 3, 2, 1 is there. Like that, this is also a mandate. There, if you observe, number of directors falls below statutory minimum. 3 required, but only 2 are there. 2 required, only 1 is there. 1 required, no one is there. In such a case, what to do? You can add the directors and make additional directors appointment. Like that, you can write some answer. But here, if the number reduces, what will happen? Central government has to appoint. Okay, so 9 should be there, sir. If there are only 8, what will happen? Let us understand that point very clearly now. See here, sir. Have a look. Please see here now. In Sebi, we require 9 members to have. For example, one of the member vacated and went away. 9 become only 8 members Sebi. Sebi will take decisions. Sebi will take what, sir? Decisions. Where it will take decisions? Sebi will take decisions in the meetings. In the meetings. At what? Regular intervals decided by the Sebi committee will be there. Central government will decide. Weekly twice or weekly once or weekly 2-3 times or sometimes they will decide. They have to conduct meetings. In the meetings they will take decisions. For example, a company is going for a listing. Some frauds are there against them. Whether to accept the listing or not to accept the listing. Whether that company's recognition of stock exchange must be granted, not to be granted. Stock exchange has to decide. Sebi has to decide by the conducting a meeting. Members will come, sit at the meeting, they will take a decision. So meeting is the most important thing in Sebi establishment. Okay. So now listen carefully. That's why Sebi there will be no hearing. There will be only meeting. Meetings will be conducted by Sebi. Okay. So therefore, the point is Sebi will conduct the meetings. Okay. Meeting decision must be taken. 9 members will be there. They will be attending the meeting. Absenteeism is okay, no problem. But 9 members should be there at least. So for example, 8 members are only there instead of 9 members in Sebi. Okay. Now today is 24th October 2021. Today, Reliance India Limited's case came to Sebi. They conducted a meeting. They took a decision. Okay, they took a decision against to Reliance Industries Limited. Now, what the Reliance Industries Limited legal advisor has to do? He can file an appeal against Sebi to SAT, Securities Appellate Tribunal. Instead of doing that, this person said that I require 9 members in Sebi, but your Sebi is having only 8 members inside. Unconstitutional. It is not having perfect composition of number of members as said in Sebi Act. Therefore, Sebi is ineligible, disqualified to give a decision, he is arguing. Rather than filing an appeal, you are talking about Sebi's composition. Is that correct or not is a debate. So law said very, very clearly that if number of members in Sebi are lesser than the requisite number, no problem, you shut your mouth and make an appeal. If you don't want the judgment, if you don't want to take the judgment of Sebi, you go for an appeal. That means questioning should not happen on the composition of Sebi. If number of members reduce also, decisions taken by Sebi will not get invalidated. They still be validated only. Who said that? This said that vacancies not to invalidate the proceedings of the board. Meetings will be conducted, those are called proceedings. Acts of the board shall not be invalid by reason of vacancy or defect in the constitution or any other irregularity or any defect, because of any vacancy, because of any defect, because of any irregularity. If Sebi composition is not perfect, okay, then even then decisions taken by Sebi will be valid. You can't question the acts of Sebi. You can make an appeal, that's all. Clear everyone? Sir, 9 members should be there, sir. Really 8 members concept will come, sir, practically. Do you know one thing? Today there are only 8 members in Sebi. See here. This is the board of Sebi today. Okay. You look here. Hot water here. Throat infection. See here. Ajay Tyagi, chairman. Shri G. Mahalingam, he is a whole-time member, Sebi 41D. 41D means last column. Other members. Whole-time director, whole-time member. Whole-time member. Ananta Barwa, whole-time member. Okay, 3 whole-time members are there. That condition is satisfied. Okay, we require one chairman. After that, 2 persons, one from MCA, one from Ministry of Finance. Ministry of Finance, third one, KVR Murthy, Ministry of Corporate Affairs. Okay. And M. Rajeshwar Rao, he is from RBI. Okay. Next, this person is from a part-time member. Any part-time member can be there, 2 part-time members. See here. but there is only composition with 8 members. 1, 2, 3, 4, 5, 6, 7, 8. That means one part-time member is missing. Okay. Madhabi Purabash. There is one person, one lady used to be there. She resigned and she went away from Sebi. So that's why vacancy is created. Now in this case, all the judgments passed by Sebi during this period will be invalidated. No. So that is our internal issue. Why you are bothering about that? So that's what the Sebi want to convey. So I hope everyone understood the logic clearly. So see here. So now we completed management of the board. See yes. What are the powers? General superintendence, management of the affairs of Sebi. Qualifications required. Sir, listen carefully. 2 members are there. Ministry of Finance, Ministry of Corporate Affairs. Okay. Ministry of Finance, Ministry of Corporate Affairs, the person itself means he will be having fantastic qualification. Again, we need not ask. One member from RBI also, RBI member, you are questioning his qualifications. Therefore, Sebi Act is saying that qualifications of chairman and 5 other members, their qualifications only will be said in the Act. So see here. Qualifications of the chairman and 5 other members, capacity to deal with problems relating to the securities market, special knowledge in law, obviously law knowledge should be there, finance, okay, stock market, finance related, you need to have economics, obviously stock market is a branch of economics, accountancy and administration, because listed companies will file their documents with Sebi, therefore accountancy knowledge should be there, administration knowledge should be there. These people, which people? Chairman and 5 other members. Next issue. Term of office. Okay, see here, sir. Term of office. 3 things are dealt in this particular section now. How many? 3 things. Number 1. See here, sir. Number 1. This is all said in section number 5. What section deals with? Term of office, conditions of service, termination of office. So, term of office of chairman, term of office of 5 other members. Okay, or conditions of service of chairman, conditions of service of 5 other members. Termination of office of chairman, termination of office of 5 other members. Means 3 members are there, MCA, MFA, RBI. Those people details are not covered here, will be decided by that entity directly. Next, term of office, chairman and whole time members. Chairman and whole time members. Not even part time, whole time. 3 whole time member, 1 chairman. Those people. Maximum tenure 5 years. Maximum age 65 attaining. So the term of age and the term of office and age limits. Who will be covered? Chairman and whole time member. Maximum tenure for 1 person will be 5 years. Maximum age attainment will be 65. Next. Now we are going to deal with removal and resignation of members. Listen carefully. Can CG remove and terminate? Yes. 2 options are given to central government. You either give a 3 months notice in writing. In that case, you need not pay any compensation. If you want to remove him immediately, without even a 3 months notice, pay 3 months salary. Compensation. That means if you are giving, I am giving notice today and I am saying that you will be removed from month of March or April. Next financial year beginning, you are not a member, I said. I have given advance notice to him. Today it is October, November, December, January, February, March. 5 months advance notice we have given. In that case, no compensation. Today I am giving a notice saying that from 1st November another person will substitute you, I said. In that case, pay 3 months salary to me. Okay. Next. Compensation. Now, can the chairman and members resign themselves? Yes. They have to give by giving a 3 months notice in writing. They don't have a chance to tell government, I will pay you 3 months salary and I will go today itself. No chance. You have to give 3 months notice. So, this is the answer. So, another 3 questions are also completed. Next one. Removal of members. Removal of members. See here. Removal of members. Who has a power to remove? Central government. When? Insolvent, unsound mind, convicted for offense, abuse of a position. If you are convicted for any of these 4, remember only the keywords, sir. In examination, those keywords only they will look into. First one, insolvent. Next one, unsound mind. Next one, convicted of an offense involving moral turpitude, abuse of position, adhikara durviniyogam. Any of these 4 things if you have done, you will be removed. But what will be given before removing you? Opportunity of being heard shall be given before removal. So let's repeat once again to the concept. So the main idea behind this is removal. Let's complete faster. Main concepts you need to concentrate more. Small bacha concepts just you can read and go. So those concepts, let's not waste the time. Central government has a power to remove in 4 cases. Number 1, insolvent. Number 2, unsound mind. Number 3, convicted. Number 4, abuse of position. Next one, meetings of the board. So meetings. Why meetings? SEBI will take decisions at the meetings here. So meeting, how to be conducted, when to be conducted, what is the nature of conducting, notice how many days before, nothing is there in the act. They will be decided by SEBI regulations. SEBI regulations will decide. Okay. Assembly is there, parliament is there, Rajya Sabha is there, speaker is important person. Okay. Even in the board meetings, the chairman must be present. Likewise, even in case of SEBI, chairman must be present. Therefore, chairman of the meeting and exceptions to that, let us read. If the chairman is present at the meeting, then he shall be the chairman of that meeting. If chairman is unable to attend the meeting, any member chosen by other members present shall be the presiding officer. We don't call him chairman. Chairman means for all the meetings he is the chairman. In his absence, temporarily if a person comes and sit there, we call him as a presiding officer, not as a chairman. Next one. What is the decision making? Unanimous approval, special resolution, majority, simple majority, which kind? All questions decided by majority of the members presented and voted. Majority. 9 members are there now. 8 present at the meeting, 1 absent. Not 1 removed or resigned. Absent to the meeting. Here 5-3 is the majority. 7 only present, sir. In this case 4-3 will be the majority. Like that, majority of voting they will check. Okay. There is no unanimous majority, etc. Next, sir, equality of votes has come. What to do? The chairman or the presiding officer shall have a casting vote. Casting vote means second vote will be given to him. Clear, sir, everyone? So therefore, meetings. First one decided by the SEBI regulations. If the chairman is present at the meeting, then he shall be the chairman of that meeting. If he is unable to attend the meeting, members chosen among themselves will select one person to preside over that meeting, called as a presiding officer. Okay, all questions, majority of votes, equality of votes, the casting vote will be given to the chairman or presiding officer. Next issue. Now, in the board meetings chapter, there is a concept called as an interested director. There is a concept called as what, sir? Interested director. Sir, who is an interested director? 184 subsection 2 of the Companies Act discusses about interested director. Interested in a contract or arrangement. When that contract or arrangement is discussed, if you attend the meeting, obviously you will vote only in favor. That should not happen. Favored resolutions should not color the board decisions. Therefore, you will be disqualified from voting. You will be disqualified from present at the meeting. Like that, we will be knowing about 184. Same thing. Reliance India Limited is coming up for discussion. Meeting la, whether Reliance India Limited should be given a chance to go for further public issue or not has to be decided by SEBI. Meeting conducted. SEBI matter came to the point. One of the member of SEBI is having some shares in SEBI. Sorry, having some shares in Reliance Industries Limited. He will be an interested member. What to do now? Let's see. Conditions. Condition 1. He is a member of SEBI. Okay. He is also a director whose matter has come up for consideration at the meeting, and he also have a pecuniary interest in that matter. 2 things should be satisfied. Member of SEBI must be a director of that company and having some financial relationship with the matter going on. For example, a company went for public issue. Public issue it went. Application money also accepted. Application money also accepted. Allotment time la some problem came, matter went to SEBI. Allotment time la problem came, matter went to SEBI. SEBI has to decide now. One of the person who applied for application money is one of the member of SEBI. He is also a director of that company. Now I am a director having some financial interest in that matter. Okay. In such a case, disclose the interest, and the disclosure what he made must be recorded in the minutes book, and he shall not take part in the meeting. Next issue. Vacancies concept I already Right, completed. 10 questions we completed. Now just like that, using the charts. Hope everyone understood the logic up to here. Say yes, we go to the next part. I think everyone completed now. Okay, next issue. Collective investment scheme. What is this, sir? Collective investment scheme. Okay, sir, after collective investment scheme, this is the point. After that, cease and desist proceedings, regulations, functions of the board, all these things will continue. Okay, power to issue directions, investigations conducted, search and seize, miscellaneous administrative aspects, prohibition of manipulative trade practices, lastly the judiciary aspect. Okay, so judiciary aspect is just punishments and penalties we need to remember. So let us start with the administration areas. Just a minute, sir. Securities Appellate Tribunal. Okay, let us do the administration issues on Sebi. Okay, Sebi la 3 parts are there: board, judiciary, administration. Board completed. Let me complete administration. Lastly, bacha concept of judiciary. Judiciary high content, but concept is very less. Easy to complete. Very, very easy. Not so difficult. Charts material are dead easy. You need not even bother. So see here. Collective investment scheme. Okay, collective investment scheme. Okay. Just a minute, sir. Okay. Look here. I don't know what you really have a concept or regarding. I don't know exactly what knowledge you already have on collective investment scheme, but as far as I am concerned, students are worried about administrative aspects of Sebi because they are not understanding what is collective investment scheme, cease and desist, what the hell is going on in this chapter. So everyone is getting that doubt. So let us have a full clarity on what is this idea of Sebi administrative aspects. Okay, so the main point with regard to this particular economic law Sebi chapter, administrative aspect seems to be difficult for the students. Generally, I'm talking about. Okay, in general, they are feeling it much difficult to cover. So let us first understand one point. So listen. What is a collective investment scheme? Okay, what is a collective investment scheme? Let us see what it is very clearly. Okay, first. Koushik Mukhesh is there. He want to purchase a commercial building worth rupees 20 crore. Why? What is the purpose? From this it can generate income. Income we call it as a rental income, lease income, whatever you call, lease rental or normal regular rentals. So this is the basic idea. I want a rental income, fixed rental income every month, such that it will be a settlement for me. Okay, every month if I am getting 1 lakh or 10 lakhs or 5 lakh like that, continuously recurring rental income, peaceful life. Therefore I thought to have a commercial building of at around 20 crore rupees. In that 10% also not there. Then how can we purchase? People like me, in every 199 are like this only. No one have money to invest 20 crores all of a sudden and purchase a commercial building. Okay, that too in Hyderabad. It is very, very difficult for us to afford like that. Everyone will have a idea or a dream to have a commercial building such that they will get a regular rentals. But everyone cannot achieve that. It is impossible to some people. It may be possible only after long lasting efforts, but almost it is very difficult to reach that. 20 crore rupee commercial establishment means it's not a joke. I want rent from that again. That's the point. So can we? No. Or at least there is a big building, apartment we call. So there will be totally in one tower of the apartment, we will be having around 200 houses. In that, one house will be costing 2 crore. For 2 crore, one house also I couldn't afford. Let's say for example, okay, 2 crore, one house also I can't afford. What to do even in this case? I want rent from that, or I want a own house. I want rental income from that. I want an income. Without having an asset, how can you get the income in India? It is not possible. Okay. Therefore, people like me will be always feeling sad that they are not getting a proper fixed rental recurring income. For them, as a investment point, a concept was formulated with the name collective investment scheme. What it is? A collective investment scheme. So what it is, let us try to understand clearly in detail. Basics understood, now concept just like that you will complete. Listen. There will be large number of investors. Okay. There will be large number of investors. There will be a promoter. Promoter of what? Of a real estate project. There will be investor. There will be a promoter of a real estate project. Okay, two persons are there. Investors directly they couldn't invest in real estate market, not possible. What they will do? What they will do is another mediation concept came. This person is called as real estate investment trust. Real estate investment trust. Name itself is very clear. It's a investment made in the real estate market. Okay. Now, what this? Sorry. What this person will do? Look here. What he will do? This real estate investment trust is a special purpose vehicle. Special purpose vehicle established under the Sebi Act. Entity will be established under trust as a trust, but governed by Sebi, Securities and Exchange Board of India. What it will do, let me explain. Investors are interested to invest in real estate market, but one building 2 crores na out of dream. Even in a dream, I will not dream about 2 crore investment in one house. My maximum capability is 30 lakhs here, 20 lakhs here, or 10 lakhs only, or 5 lakh only, or only 1 lakh I can give. Okay. From the investor, this real estate investment trust will collect the money. Okay. These investors will be paying good amounts to the real estate investment trust. This real estate investment trust, sir, how to believe an outsider? This special purpose vehicle will be having three parties. Number one, the sponsor. Number two, the manager. Number three, administration. Administration means they will look after whether money is properly diverted to the market or not, like that they will see. Manager, overall management of real estate investment trust. Sponsor is the promoter of the trust. All these three people requires registration under section number 12 of Sebi Act. Yes, these people are called as a market intermediaries. They must get registered with Sebi. Without registration, real estate investment trust can't form in India. Sebi registration is mandatory if you want to take money from public. Okay, so if it is a private trust, no problem, but if it is a public trust, must and should you should get registered with Sebi. So listen carefully. Investors will give money to the real estate investment trust. Okay, real estate investment trust will collect money from them. It will pass this amount to the promoters of the real estate project. Let's notate a name for this. You name this project as Aparna Constructions, My Home, so on. You put any name, those people will receive money from them. Advantage is investors are giving money to them. This money is getting diverted to the real estate project. You can ask a question, sir, directly these investors can give to the real estate project, and sir, why this mediator is required? Listen carefully to the point. If you give 20 lakhs to Aparna Constructions or My Home, they will not even give us a washroom. Okay, for 20 lakhs to 10 lakhs, they will not give even that. Then what to do? I can't invest there. If I give directly to the project, what they will do? They will not even give anything as a registration to you. I make clear, even garage la small room also they will not allot you for the 10 lakhs or 15 lakhs or 5 lakh or 1 lakh, whatever you give. That means I will not give you ownership in the house. But what we will do, listen, that's the entire story. This real estate investment trust, in return, what it will do, this promoter will start issuing the units. Will start issuing what, sir? Units they will issue. Money will be collected by the promoter company. Yes, money will be collected. They will price unit as 10 rupees. Let us say for example only. Okay, let us say for example only. Let's say for understanding sake 10. It can be 20, it can be 45, it can be 50 also. How that will be calculated? Sebi valuation. Registered valuation course is there. They will value the unit price of a particular unit. Let us say for simplicity's sake 10 rupee. Investors have given 100 crore rupee. How many investors are there? There are 10,000 investors from whom the money of 100 crores is pooled. 10 rupee is the unit price. Rupees 10 means what? 10 crore units are issued. 10 crore what are issued? Not houses, units are issued. 10 crore units of rupees 10 each were issued. Now promoter will authorize real estate investment trust to issue the units. These units actually issued to investors. For example, Koushik Mukhesh has given 10 lakh rupee. How many units I would have got? Simply I would have got 1 lakh units. I would have got how much, sir? 1 lakh units I would have received. So units will go into the hands of investors. Now listen to the point. Now these investors invested in the real estate project? No. Therefore no registered ownership. That means 10 lakh rupee given by Koushik Mukhesh. He went to Aparna Constructions or My Home Group. He said, I have given 10 lakh rupee. Which room I am owning now? They will tell that, who are you? I am Koushik Mukhesh, I gave 10 lakh rupee. 10 lakh rupee to whom? To real estate investment trust. Then you will not get this room, nothing you will get. You will get income from this property. That means this particular building is there, na? Some portions are kept for commercial establishment. Rent will come, na? In that rent you will get a portion. Means what? Means what? Means, see here. This real estate project, one commercial building is there. One tower is full construction of commercial buildings. Let us say, for example, that the total tower has given a rent of, listen carefully to the logic, has given a rent of, let us say, rupees 2 crore in a month. Monthly 2 crore revenue came. 2 crore revenue, like Koushik Mukhesh should not tell this 2 crores belongs to me because I invested 10 lakh. You invested only 10 lakhs. Okay. 2 crore rupee income came. This 2 crore rupee belongs to whom? 2 crore divided by, there are totally 10,000 persons who participated. So to be very clear, 2 crore rupee is there. Number of units are 10 crore units are there. How much? 10 crore units are there. 2 crore rupee came. 10 crore units la 2 crore rupee means how much you will get? 0.2 rupee per unit you will get. How many units you have invested? 1 lakh units you invested. 1 lakh units into 0.2, you will get 20,000 rental income. What you will get, sir? Rental income you will get. 20,000 rental income. Previously, can you afford in a property which can give you 20,000 rupees revenue? No. But today, investors are getting 20,000 rupees revenue as a rent, though they are not owning any property. How it is possible? That is possible because of real estate investment trusts. These are called as collective investment schemes. That means they will collect investments from various persons, start a unit, trust company called as a real estate investment trust that issues units with the authorization of the main promoter, which will be issued to the investors. Rental income will pass on to the investors. This is how it will be made. This is the concept of a collective investment scheme. That means investor don't invest in property. Investor make investment in a security related issue called as a units. Since a house is not involved, since units are involved, Sebi involved in the case. Who involves, sir? Sebi involved in this case. This is the whole idea behind the concept of real estate investment trust. Okay, this is what you want to talk about, collective investment scheme. Simply to tell, after all this discussion, normally shareholders will be there. We call investors. They will participate in management. They will participate in decision making. Yes or no? They will get a fixed dividend. They will have rights on the company. Here investors don't have any right over the company. They will only invest for the purpose of making income or profit. I repeat once again, you should also repeat. They are investing only for the purpose of making income, not to have ownership, not to participate in management, not to take decisions. Clear? With this, reads collective investment scheme concept. Exactly 5 minutes we'll close CIS concept. Okay, last one concept. See here, sir, investor can't go to promoter directly. Clear? Sir, I am in Hyderabad now. I want to go to, example, I want to go to Delhi. Now I am internally what I feel is I have to go to Delhi. My feeling will make me to reach Delhi. There should be some vehicle to make me to reach. What is that vehicle? That will be flight or a train or a car, a vehicle, whatever the vehicle you call. That means when I can't reach a destination, some channel must be there which can make me to reach there. Likewise, when investors also can't reach the real estate market, there should be some vehicle to take me. That vehicle is now called as real estate investment trust. That's why it's not a physical vehicle. That's why it's called as a special purpose vehicle. It will take you to the destination artificially and virtually. That's how the name of special purpose vehicle has come into the act. This is the idea behind collective investment scheme. Everyone understood the concept clearly? Sir, on whose name documents of property will be registered? Are who purchases the property? That person's name will be there. Some owner will be there, na? Sorry. Anyway, so this is the whole idea behind the concept of Sebi. CAS in Sebi. Let's go back. Now you read the concept of CAS, how beautifully you can clear that, how easily, how fastly we can do. Contribution and payments are pooled from various investors, utilized for scheme. One thing, pooled from investors. Okay, diagram you need to keep in mind. Investments are made not to claim ownership in profits and income. Scheme is managed by manager. I am not a mad fellow. Point number 1. నేను పిచ్చోని అస్సలు కానే కాదు, అందుకే రాసింది మేనేజర్. Investors don't have day-to-day control over the management. I told you very clearly, you are not registered owner or any other scheme asset by CG is called as collective investment scheme. What shall not constitute a CAS means what is not a CAS. Okay, first thing, let us first start with point 2. Point 1 lastly we will read. Scheme or arrangement offered by NBFC. Why it is not a collective investment scheme? These are governed by RBI, not by Sebi. Next, third one, scheme or arrangement offered by insurance company, because it is governed by IRDAI and Insurance Act as well. Therefore, separate governance is there. Then why I will call CAS under Sebi Act? Any scheme offered by EPS and EPFS, okay, Provident Fund Pension, because these are governed by Labor Ministry separately. Separate concept is there. Therefore, though it is something similar to CAS, I will not call it a CAS under Sebi Act. Scheme offered under section 58A of the Companies Act. This is called as a deposits concept, and this is governed by Companies Act. Therefore, no. Scheme or offer arranged by Nidhi, Companies Act is already governing it. Scheme offered by chit fund company, RBI is governing it. Mutual fund, already Sebi separately governs mutual funds. Simply, if any concept similar to CAS is there, which is already governed by Sebi Act separately or by any other act in India, RBI, whatever you call EPF Act, IRDA, Cooperative Societies Act, Companies Act, Sebi, whatever the governance is already there, Sebi will not touch that. That means plural governance will not be there. Plural governance means one entity governed by two different entities. That's called as a plural governance. That concept will not be there. Okay, so this is the whole idea. So scheme or offer arranged by society or corporate, separate act is there. Society Act is there, Cooperative Society Act is there. I think you are clear about what I said. So therefore, when a scheme is given by that particular act, those are not covered. Scheme given by a company, but not 58A, not deposit. Other than that, Sebi will govern that. Okay, so now, which is not a CAS registered, it is not registered as a CAS, but I will call as a CAS if the capital is 100 crore or more. Mark it, important question for MCQ. Okay, if the corpus means the capital of that trust is 100 crore or more, then even though it is not registered as CAS, it is working for a real estate project but not registered under Sebi, we call it as a Sebi, we call it as CAS, compulsory registration will be applicable to them. That's all. This is the whole idea of CIS, collective investment scheme. Now you put a message, everyone, concept is difficult, huh? Hardly take some conceptual clarity, that's all. Once you read, it will be easily completed here. You should put some effort in understanding the Sebi Act. Sorry. CAS completed. Next, cease and desist order. Sir, what is cease, what is desist? Cease means stop, desist means going to occur, stop him to doing that, is called as a desist. Okay, so Sebi is having power to do two things. Okay, it can pass cease orders, it can pass desist orders. Cease for what? Violations already committed. Desist order for what? Likely violation of Act rules regulations completed. But there is a limitation for this. SEBI may pass cease and desist orders on a listed public company, on a listed company or a public company only if a company intends to get its shares listed and involves in insider trading or market manipulation. Sir, what is this? See here. There is a listed company or there is a public company which is unlisted, now going for listing. You can pass a cease order against them only in one case by satisfying two conditions. First thing, during what? During listing, if they are doing any kind of insider trading or market manipulation, then only you can pass cease and desist orders against listed companies are likely getting listed. So then on whom they will pass at any time? Stock exchanges, market manipulators, market participants, intermediaries. ఇదంతా ఏం చేశారు మరి? ఒక్క కంపెనీకే ఇది ఇచ్చింది, మరి మిగిలిన బ్యాచ్ అంతా ఉంది కదా, ఫ్రాడ్ బ్యాచ్, వాళ్ళందరికీ ఇది అప్లై అవుతుంది. To be very clear, cease orders and desist orders you can pass at any time, at any occasion, whenever there is a fraud. In what? In whose case? Any case. But if it is the listed company or an unlisted public company going for listing, you can pass a cease and desist order only if two conditions are satisfied. Now the company intends to get the shares listed and it involves in insider trading or market manipulation. These are the 2 points. Next. Next one. Regulations by the board of regulator prohibit the issue of prospectus. Okay, so first one, manner of regulations by SEBI. SEBI may pass regulations, may give regulations or may give orders. Regulations are of two types: ICDR regulations. ICDR, issue of capital, regulates the issue of capital. LODR, we already have in the syllabus. Okay, it is required after listing. Okay, next, orders. That means SEBI can pass regulations, SEBI can pass orders. Regulations are of two types. One is ICDR, another one is LODR. ICDR not applicable for exam, LODR anyway applicable for exams. Next one, orders. Prohibit any company from issuing prospectus in a contravention. For that regulations are not there, orders will be passed. Next, section number 12. Registration of, so this is important point, sir. Section number 12. Just now I said everyone should get registered with SEBI under section 12. Now, who are involved? Let us see. Sir, first thing, everyone in the class listen carefully. We should not mug up the concept, understand the sequencing of stock issue in stock market. First one, whenever we have to purchase the shares in the market, we require a stockbroker. First person requiring registration. Persons working under him, sub-brokers. Okay. Next one is depository is required. Depository is required for what? Transfer of shares from one person to another person. That person can do fraud. Therefore, share transfer agent in a depository will be the next one. Next issue. Whenever a company is going for a public issue, merchant bankers and financing bankers will be there. Bankers are of two types: financing bankers, merchant bankers. What is financing bankers? Listen. Whenever we are going for a public issue, directly no public will give money. They will first see how much debt equity component is involved. Banks are there, they are giving 200 crores. Public will be there. Okay, bank is giving 200 means without a due diligence, why they will give 200 crores to him? Therefore, we will give another 500 crores. Like that, they will get motivated. So, they are called as a bankers to issue. Once a public issue is completed, or once a prospectus is prepared, registrar will register the prospectus. We know that concept, very very important in CA IPCC. Without registration, prospectus don't get validity. That registrar can do fraud. Therefore, he requires registration. Just now we read real estate investment trust. Trust will have a trustee. They require registration. Merchant bankers, underwriters, portfolio managers, investment advisors, foreign institutional investors, sponsors, credit rating agencies, all these persons requires registration under SEBI. Okay, so whatever they want to do, they want to buy the shares, sell the shares, deal with the shares or securities, they have to do only after a due registration being made. So who are there? Market, let us assume. Stockbroker, sub-broker. One point completed. I want to transfer the shares. Share transfer agent. Whenever public issue is made, banker is required bankers to issue. Next, registrar has to register that. If there is a real estate investment trust, trustees, merchant bankers, underwriters, portfolio managers, investment advisors, all these people clubbed together, all require registration under section number 12. Next, functions of the board. Functions of whom, sir? Board. Okay. See here. What is the preamble of Sebi? What we already read. The preamble of Sebi is establishment of a board for protection of investors, etc. Now he is asking what is the functions of a board, not act. Sebi functions: protection of investors, promotion of stock market, regulation of securities market. Completed. Next, this is a basic function. Other functions are also there. Let's have a look. Regulating the business of stock exchanges and other securities market. Stock exchange and other security market. Registration on regulation of following persons: stockbroker, sub-broker, share transfer agent, bankers, trustees, merchant bankers, portfolio. Same whatever we read. List. That's why we first read that. Promoting investor education. For this only IEPF account will be formed. Prohibition of insider trading. Regulating substantial acquisition and takeovers. One company taking over another company. Along with the section number 235 of Companies Act, SEBI guidelines will also apply. Whenever some wrongs or frauds are presumed to happen, you can call for a inspection, inquiry, investigation. Powers are also there. Summarize everything. Let us see what are the functions of SEBI. Protection of investor, protection of securities market, regulation of securities market. Regulating stock exchanges. Next one, registration of all the list of persons. Insider trading prohibition and promoting investors education, takeovers and acquisitions, and inspection, inquiry, investigation powers. These are all the functions of the board. Not yet completed. Civil code powers will be there. What are the civil code powers? Many times we read this. 5 points will be there. Whenever I get a doubt, I will call the person. Stockbroker, I have a doubt on you. You are charging higher brokerage than what are the required by the regulations. So come for inquiry. Summoning means demanding the presence. If you don't present on demand, enforce the attendance. By hook or crook, I will make you to present with me. Number 1. Promise and tell all the truths. Examination oath. Discovery and production document. Discovery means search. Production, seize. Seize and search powers, or search and seize powers. On that I will make inspection. Issuing commission means passing a order, final order. 5 civil code powers: summoning and enforcing the attendance of a person, examination of discovery and production, inspection, and passing the final orders. Powers during investigation. Okay, powers during investigation. And moreover, amendment area. Not this attempt, previous attempts amendment came, not asked in exam, marked important for the examinations. This part from here to here, chance is there it can be tested in the very coming examination for the December. So please make sure that you are perfect with this concept. Powers during investigation. What are the powers of SEBI during investigation? First, suspend the trading of any security in recognized stock exchange. Small printing mistake is there. Suspend the trading of any security in recognized stock exchange. Okay. Next, restrain means stop persons from accessing the securities market. Okay. Now here, first, any one company's security was suspended. Suspension means temporary. Restrain persons from accessing the securities market. Now securities market is not prohibited. Stockbroker, sub-broker, those persons are restrained. I can do that. Impound and retain the proceeds or securities. Impound means take into custody. Next, attach the bank accounts or other property of any intermediary. Intermediary means whom? Persons covered under section number 12. Large number of stockbrokers, sub-brokers, share transfer agent, trustee, merchant bankers, investment bankers, portfolio advisors, FII, sponsors, credit rating agencies, all these are called as intermediaries. attach the bank accounts and other property of intermediary who involved in violation of provisions. Levy penalty. Penalty we will see anyway, judiciary point. Direct any intermediary or a person associated with securities market not to dispose or alienate any asset forming part of any transaction which is under investigation. Simply this is freezing of assets concept under Companies Act type. Whenever we are going on investigation, we will freeze the assets. No one can transfer the assets subjected to investigation. I can do that. So let us see what they are once again, everyone. Powers during investigation. First thing, suspension of trading of a particular security I can do, number one. Number two, I will prohibit some persons to access the securities market, number two. Number three, take custody of documents and securities and amount. Number four, attach the bank accounts. When attachment is done, some points are also there. Maximum 90 days. If you want to go beyond 90 days, okay, board shall within 90 days obtain confirmation from the special court. Sir, can I go beyond 90? Let us see. First attachment is for 90 days. To get that attachment right, special court confirmation is required. Okay. Next one. Upon confirmation of special court, provisions of 28A shall apply. 28A lastly it will come. Only such property or a bank account which are related to proceeds involved in violation shall only be attached. Not their personal bank accounts, everything. Commercial account which is linked to that violation. That means, for example, Koushik Mukhesh is a stock broker. He is collecting brokerage. Which account? There will be authorized account. That account only will be there. Attachment means you can't attach my father's property, okay, or my brother's bank account. All those things you can't do. My bank account, that too, the linked bank account to the fraud, that only you can do. So attachment will be made 90 days. Special court permission is required. Within 90 days you need to take it. Under 28A conditions has to be satisfied. And lastly, 90 days is the maximum time period given under the Act. Okay. So this is all about the powers during investigation. Sir, hope this is a new point for everyone in the live. I am putting it. Take a minute time. Observe all the conditions inside. Okay, let's continue. Sir, everyone understood the concept clearly? Everyone understood the concept clearly? Can we go to the next one? Hello, everyone understood the concept clearly? So let's start with the next issue. Power to issue directions and levy penalty, section number 11B. Okay, let us see what it is. Power to issue directions. So simply the words used are direction, means to do something. I will direct you. Okay, that's a one point. Next one. When Sebi, who has a power? Sebi is having a power. When Sebi issue the directions, it is necessary in the investor interest, or for orderly development of securities market, or preventing frauds and other detrimental affairs in a business in the investor and securities market, or for proper management of security market. Simply in the total interest of capital markets, I can issue directions. Investor protection or for development of securities market, to stop wrongs happening or to have proper management of securities market, I will issue directions. Directions to whom? Directions to persons under section 12. Other than section 12, any person associated with securities market called as directors in company, promoters, all these persons. And 11A. 11A means any real estate investment trust, all these will come. Next. Levy penalty. What it can do? If any of the persons associated with securities market or bunch of people under section 12 or company under section number 11A, if they are doing anything against to the interest of investors, if they are not supporting the development of security market interest, or if they are doing some frauds against to the securities market, they will have to do two things. Penalty will be levied under section 15. We will read that. Along with that, disgorgement will happen. Disgorge means what? Recover and pay. Disgorge. Okay. Sebi has a power to issue directions to a person to disgorge who made a profit or who averted a loss. That means because of doing a fraud, one of the person has made profit, recover that profit back. One of the person has done fraud because of which investors made a loss, then recover from him and pay to the person who averted the loss. Simply collect from the person who has done the wrong and give to the person who has been victimized to this particular issue. That's all. That's concept of power of Sebi to issue the directions. Next issue. Investigation. Separate provisions on investigation are there. Mark it important. Expected question for the December exam because it is not asked in any of the previous attempts. Yes, I mean it. It was not tested in any of the previous attempts. Let's see. Investigation, section number 11C. First, what are the grounds for making investigation? Obviously, you are making some transactions against to the interests of investors, or any intermediary, means section number 12 person has violated act rules, directions, etc. Okay. Second one, power with whom? Who will initiate investigation? Sebi. In Companies Act, MCA, central government. Okay. Duties of Sebi. Obvious duty. Investigation chapter, if you listen to the revision, this is very easy. Investigating authority will be doing report sent to the Sebi. Their report sent to the central government, here report sent to Sebi. Okay. Duty of various persons. Sir, Companies Act law, whose duty? Officers and employees of the company must give all information, explanations to the best of the knowledge. Same thing. That's all. Intermediary and persons associated. Manager, MD, officer, employees of company referred under section number 12. What is their obligation? Produce the books, registers and documents. He can keep in custody for maximum 6 months and shall give certified copies is required. That means he can give back copy. Sir, 90% of this topic is similar to our normal investigation or not, but we will not read. Because in pages, it is large, it is big. But we are not even going to read what is there. Once you read, you will understand nothing is there. So, grounds of investigation, these two grounds you can investigate. Clear? Power with whom? Sebi. What they will do? Investigating authority will be appointed. He will send back a report, obviously. During the investigation, it is a duty of the intermediaries and other persons. If company is under investigation, that company manager, MD, officer, employee, all these persons will give all the information and books to him. He will keep it in custody for 6 months, and if you want, he will give back the copies to you. Completed. Next, continuation. Continuation. So 3 pages answer, sir. In notes, if in institute material, if you see 3 pages, sir. But in chart, we summarized to a maximum point extent possible. Sebi power to search and seize. Okay. So same thing, sir. If you remember, Companies Act, section number 209 will be talking about search and seize. Section number 220 will also be talking about search and seize. Same concept. Where the registrar or inspector has a reasonable ground to believe that the books and papers of the company are likely to be destroyed, mutilated, altered, falsified, or secreted, he can enter into such place where the books are kept, and he can take the copies or place identification marks. And before making any kind of seize, he shall take the permission of a special court. This is what they said in section number 209. 220 one point was added, related entities also. He can make an investigation and he can make a search and seize. Same thing even here. See here. Basic power. Let us see. Power with whom? Investigating authority. Seize with whose permit? Magistrate or judge. Their special court here, magistrate or judge. Of which court? Court in Mumbai, because the head office of Sebi is there in Mumbai. What are the powers of magistrate judge? Authorize to enter such place where the books are kept. Search, seize. Okay. When you can exercise that powers, has a reasonable ground to believe that the books and papers are likely to be destroyed, mutilated, altered, falsified, secreted. Answer completed. If you want, you can take police assistance and you can keep the records with you till investigation. Bacha concept. Correct kuchunda arani visham. మనం కూర్చోం అంతే, అదే ప్రాబ్లం. అర నిమిషమే ప్రాబ్లం అవుతుంది. ఒక్క పావు గంట స్పేర్ చేస్తే అయిపోయా చాప్టర్ది. 5 మార్క్స్ పక్కా. 5 మార్క్స్ 8 మార్క్స్ పక్కా. బట్ వీఆర్ నాట్ రెడీ టు స్పేర్. నెక్స్ట్ కంటిన్యూటీ. Restriction on seizure. During the seizure of books, registers, other documents and records of any listed public company, okay, obligation on whom? The magistrate or designated court, only if they are in insider trading or market manipulation. Same whatever cease and desist. Only in this case you should order search and seizure against these companies which are listed. That is small point, mainly these two. Now tell me, 3 pages content section 11C. Easy or difficult? So this is the idea of this investigation section here. Once you read Companies Act investigation chapter, these are not difficult, very easy. Sir, powers given by the Constitution of India on investigation are same. Only you need to change the name of the authority, that's all. Not so great. Next, miscellaneous aspects. Arey bacha concept here. 2 minutes only I will spare on this. 3 topics are there, section 13, 14, 15. Okay, let us see. Grants to Sebi, fund, accounts and audit. Grants. Grant by whom? Central government. Grant to whom? Sebi. Utilization of grant. Grant should be utilized only for the purpose of the act. The question. Sorry. Once the grant is received or all these things, Sebi will maintain a fund. Fund means some amount kept aside and used for some good purpose. Investment will be made. Okay. Name of the fund. It's called as a Sebi general fund. Credits and debits to the fund. What are the debits? Salary you pay from that fund. Allowances you pay. Remuneration, other expenses of Sebi. Next, credits. Grants, fees, charges, other sums received. Next, accounts and audit. They should make accounts and audit, proper books has to be maintained. Audited by C and AGI. What power C and AGI will have during the course of audit? Same as a government company. And the accounts and reports, whatever the C and AGI has audited, that will be kept before both the houses of parliament. That's our answer completed, sir. Next issue. Next issue. See here. Prohibition of manipulative and deceptive devices, insider trading, substantial acquisition of securities or control. Simply, if you are using prohibited acts, these are all prohibited under Sebi Act. If you do any of the prohibition, punishments will be levied. Okay. Now see here. Manipulative deceptive practices you are doing in connection with the issue of security, purchase of security, sale of security. Okay. of securities listed or proposed to be listed on a recognized stock exchange. During that time, if you are doing any kind of fraud, manipulative practice, you will be caught as a prohibited act, you will be punished. Employing any device or a scheme to defraud in connection with the issue of security, dealing with security. This is the most applicable for stockbrokers. Next, engage in insider trading, another prohibition. Deal in securities while in possession of non-public information. This is called as non-public price sensitive information. NPPSI means non-public price sensitive information. Price sensitive information means any information which if comes out as a public information, it will affect the prices of the securities. Those are called as a price sensitive information. Price sensitive information, if it is made public, okay. Not even made public, that's called as a insider information. Okay, using that insider information, if you are buying or while in possession, if you are issuing or if you are buying something, yes sir, I will not purchase, I will tell my friend or relatives to purchase the shares by knowing about this. Communication of such material information is also prohibited. Next, acquire control of a company or securities more than a percentage of equity share capital of a company in contravention. This percentage will be decided by regulations from time to time. You cannot acquire, one person cannot acquire max more than a particular level of shares of a particular company. How much? It will be decided by regulations from time to time. This section is a normal basic miscellaneous section, therefore don't show so much importance to it. Just remember, manipulative practices or frauds or insider trading or having the possession of non-public price sensitive information or having acquisition of a securities more than a percentage in a company, all these are prohibited acts. For that, punishment will be levied. That's all. Not so great. So just a normal concept. I already said there are three parts in SEBI: board, judiciary, administration. We completed board, we completed administration. Now the last part that was remaining is the judiciary. See here, I don't want to waste time in reading the penalties. I will leave for you to read. I'm not going to discuss about how much 10,000, 1 lakh. I don't want to waste time. I want to only discuss about what are the adjudication proceedings under SEBI. Okay, what are the adjudication proceedings under SEBI? That I want to discuss. I don't want to waste time in telling about unnecessary things here. Okay, SAT is there, I will discuss about that. Punishments are, I will discuss about that. But I will not discuss and waste the time about how much money, how much amount, all those unnecessary concepts. I don't want to waste the time. Okay, there are many concepts to discuss. Adjudication is there, SAT concept is there, special courts, I will discuss those. Penalty 1 lakh, 20,000, 30,000, I don't want to discuss and waste the time. I am telling very clearly. Okay, now listen carefully. Whenever a section uses the word liable to a penalty, it is a civil nature. Whenever section uses the word liable to a penalty, civil nature. Whenever section uses the word punishment, it is a criminal case. Okay, it is what's a criminal case. Okay, so how to understand whether it is a civil or criminal? If the section uses the word shall be liable to a penalty, civil, shall be punishable, criminal. Criminal cases go to special court, civil cases go to adjudication. Okay, adjudicating authority will be there. Now, why I am discussing about this, you should understand. 15A to 15JB, penalties and adjudication. Liable to penalty, 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 all are liable to penalty cases. Means what are all these? These are all civil proceedings under SEBI Act. Civil cases will not be prosecuted, they are adjudicated. Adjudicated by whom? Adjudicating authority. What is adjudication? Equation is there. Adjudication equal to calling for an inquiry, imposing a penalty. Tell me, sir, what is the equation? A equal to I plus P is the equation. Okay, A equal to I plus P. Remember always, forever till death. Because Life of a chartered accountant is always linked to appeals, etc. Na? Just yesterday, I have taken the class for the members qualified. There also we discussed only about this. Under Insolvency Bankruptcy Code, how to go for an appeal, how the NCLT works in Insolvency Code, how to do that course called as Insolvency Professional Course, how to deal with that, what are the challenges that the members will generally face, senior company secretaries, all these people came. So yesterday we had a discussion on that in the CMA Institute. So with regard to how to deal with Insolvency Code, and we are having all India wide sessions now because they are well impressed with the presentation made on Insolvency Code. We will be having announcement will be given soon, and I will also put in the YouTube channel and also in the Telegram channel. We are going to have an all India wide chartered accountants and company secretaries and cost accountant session on Insolvency and Bankruptcy Code. So I will be the speaker in that, talking about all the practical realities in the insolvency law, how they are really going on. All the things are linked only to one single point journey. NCLT, 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 NCLT. You should know the magic of NCLT. Once you understand that, yes, you can properly go with it. Likewise, here the NCLT position, the shoes of NCLT is taken now by adjudicating authority. What NCLT will do under Companies Act, adjudicating authority will do the same under Sebi Act. Okay, let us see. What is adjudication? Inquiry and penalty imposition. Okay, let us see. Simple concept, sir. Just have a look. Power to adjudicate. Purpose of section. What is the purpose of section? Adjudicating under A, B, everything. Okay, all the sections, whatever we have written above, to adjudicate the offense. Next, power to appoint. Sebi. Next, qualification of adjudication authority. Any officer not below the rank of division chief of Sebi. He is called as a DC. Minimum DC rank, division chief. Okay, which division? Adjudication division. Purpose of adjudication: imposing penalty, holding inquiry, or holding inquiry and imposing penalty. Actually, this box should come first, this box should come later. That's why end is there here. Okay, when we are typing, this box should come here, this box should go there. Interpose both the boxes. So holding an inquiry, imposing penalty, that's the equation. I plus P equal to A. After giving reasonable opportunity of being, that's anyway we will do. Power of adjudicating officer during inquiry: summoning and enforcing, produce any documents, civil court powers. Okay, next, special powers of Sebi. This is important, sir. If penalty levied by the adjudicating officer is erroneous. Erroneous on higher side or lower side? Erroneous on lower side. Means what? Actually, you can levy 5 lakh rupee, but you levied only 1.5 lakh. That is what the feeling of Sebi. Then Sebi can enhance the penalty. You can make an appeal. Again, as that enhancement, you can make an appeal, but it also have a power to make a enhancement. Only enhancement power is there. It don't have power to reduce the penalty decided by adjudicating authority. So powers of Sebi: if the adjudicating officer order passed is erroneous, OBH will be given, enhance the quantum of penalty. Okay. Okay, next, sir. Here if you observe, penalty minimum 1 lakh, maximum 1 crore. Minimum 1 lakh, maximum 1 crore. That means always ours is a ranging penalty. 1 lakh to 1 crore means in between anything I can levy. Who will decide? Adjudicating officer will decide. On what factors he will decide that? On 3 important factors they will decide. Disproportionate gain you made, loss caused to the investor, repetitive nature. This is a first time or you are a regular customer for this. On that basis we will levy penalty. Next. Next one. SAT provisions starts now. Which provision? SAT. Common provisions for Sebi and SCRA. SCRA and Sebi, common concept. This is a common concept for both of them. Okay. But SCRA is not there in the syllabus now. This academic laws material needs updation. Updation means some concepts has to be deleted, that's all. And amendments what made for this attempt should be added. I don't have time, that why I didn't release this. Simple concept. Okay, so many appeal cases are there, so many classes are there, so many material works are there. Question bank, it will come in one day. Okay, sir, just because of that Dasara that came between 2.5 days, they didn't work on printing. Okay, if question bank comes late, who will be the party happy? I will not be happy. Sir, no. So why I will make intentional delay? Some people will be putting messages. Question bank is delayed. Sir, our preparation completed. Sending to him is completed. So we made all the efforts to prepare that, because it's not just a 400-500 talk questions that are involved. In the question bank, what you will get on companies, only Companies Act, there are 780 questions totally. Okay. Normal books available in the market, total companies with economic law 600, 650. Companies Act 700 questions we compiled. 1986 onwards we compiled the questions here, because recent attempts, 4 complete attempts I have seen the trend of institute. They are asking questions from 1999, 2002, 2001. Those questions they are asking. Question was asked in May 2018. That question is not coming again. 1996, 97 time what questions are those questions according to current provision they are changing and they are asking. Therefore I have to go back to that. From 1986 onwards we started compiling the questions, answers given according to the existing fashion. Clear everyone? Without deviating from the institute answers again. So it takes some time. It has went for printing and it will come very soon. Tomorrow they will be coming. So listen, sir. Common provisions for Sebi. See here. Securities Appellate Tribunal. Who will establish? CG will establish. What is the purpose? Same NCLT power. Exercise jurisdiction, powers and authority conferred by or under this act or under any law. Means what? The main idea behind this is very simple, sir. The idea behind this concept of SAT, Securities Appellate Tribunal, the purpose is whatever Sebi Act said, whenever in the Sebi Act or in the SCRA, they use the word SAT, that is your power. Securities Appellate Tribunal, I told you very clearly, NCLT will not take only normal civil cases or contravention. It will do many things in Companies Act. Okay, mergers and acquisitions will happen under the guidance and suggestions and recommendations of NCLT. Merger is a civil case. It's a normal procedural compliance. Therefore SAT also like that. In SAT will exercise the powers and jurisdictions conferred by or under this act or under any other law. Means in this act or in SCRA or in any other act, if I use the word Securities Appellate Tribunal to do something, you do all those things. Okay. Next. Constitution or composition of SAT. General composition. So there will be 3 members. Presiding officer, judicial member and technical members. Okay. There are the 3 persons. Benches of SAT. Sir, what is a benches? It's like a branch office, but don't call it branch office. We call it as a bench. See here. Purpose of bench. To exercise the jurisdiction of SAT at simply to tell in your language at state level. At head office is in Mumbai. Remaining states, benches will be established. Composition or constitution of each bench. Presiding officer will be there. 2 or more judicial and technical member. Means what? 1 judicial, 1 technical, 1 presiding. Well, okay, 1 presiding and 2 judicial. No, because technical member is missing here. Presiding officer plus judicial member plus technical member. Sir, can I have 2 judicial, 1 technical? Possible. 1 judicial, 2 technical? Possible. Anyway, 2 presiding officers not possible. The concept is not there. Mandatory composition. At least 1 judicial, at least 1 technical. At least 1 technical. Where the benches are, head office in Mumbai, other places as CG decide. Transfer of members. Okay, transfer of members. That means the presiding officer may transfer judicial member or technical member from one bench to another bench if needed. So simply, let's form part of this point. KL, we have to complete. So power to establish. Central government will establish by notification official gazette. Establish that. Powers and jurisdiction. Whatever this act or any other act tells SAT to do, do that. And general composition, 3 persons will be there: presiding officer, judicial member, technical member. Benches will be established. This is the concept of a bench. Qualifications. Qualifications. What are the qualifications of a presiding officer, judicial, technical? Judge of a Supreme Court. Judge of a Supreme Court. Chief Justice of a High Court. Or judge of a High Court for at least 7 years. Highest authority will be Supreme Court. There you need to be a judge. Next will be High Court. There not judge, directly CJ. Sir, no sir, in High Court, next level person is, in High Court, you should work as a judge for at least 7 years. Any of these 3 conditions, if you satisfy, either present or in the past, you will be appointed. Qualifications of judicial member. Judge of High Court for at least 5 years, either in the past or in the present. Judicial. Technical member. Secretary or additional secretary in the Ministry or Department of CG, equivalent to the post of CG, either in the past or in the present. Having secretary and additional secretary in the ministry shall be having full knowledge of not less than 15 years in the following areas: security market, derivatives, pension fund and insurance. So you may get a doubt, sir, why pension is involved, why commodity derivatives are involved, why insurance is involved, why all these things are involved inside Sebi, inside the SAT, why they require. Let us understand before going into that. First thing, there will be 3 persons: PO, JM, TM. PO, Supreme Court la judge, or at least High Court la CJ, or High Court la judge for 7 years minimum, present or past. And if you want to become judicial member, judge of a High Court for at least 5 years, present or in the past. And if you want to become a technical member, you should directly be secretary to the government of India. Simply, do you know who are the secretary? Not personal secretary, sir. Secretary means IAS officers, 25 years experience, 30 years experience, those kind of persons. And you should have ability and experience for 15 years minimum in securities market. Sebi in a security market knowledge, understandable. Pension insurance commodity, that we will understand. Why? Because SAT will do whatever act it is. That means if Sebi Act, in the act, if they use the word SAT, SAT has to do that. Any other law, what is other law? SCRA also SAT will take. Okay. Other, Pension Act also authorizes by Sebi, sorry, SAT. PF also cases will go to SAT. Okay. Derivatives market cases also will go to SAT. Therefore, obviously, what will happen? Persons inside the SAT should have knowledge on all those areas. Okay. See here. Next. So listen. Presiding officer, judges of Supreme Court, etc. will be there. Easy to search. Rostrum will be there. Judges rostrum means the bench of judges. Past judges details are available. From that you can select a right candidate. Easy. Judicial member, High Court 5 years are very easy to search. But technical member, secretaries will be there who have knowledge in this 4. How do we know? Therefore, whenever we are appointing a technical member, a committee will be formed called as Search cum Selection Committee. That committee will be recommending the name of a technical member. Who will be there in the committee? Presiding officer will be there, who is the chairman of the SAT. 3 members will be there. 1 from Economic Affairs Secretary, Financial Services, Legal Affairs. These 3 members will be there in that committee, Search cum Selection Committee, and a convener. Who will convene the meeting of that Search cum Selection Committee? Economic Affairs Department. That means this person, Secretary of the Department of Economic Affairs. That person will be the convener. Meeting will be convened in his initiative. He will be like a chairman to that meeting. He will be convening it. Timing, when we have to meet, when the committee has to meet, what is the timings, all these things will be decided by that person. Okay. Search cum Selection. That is applicable only to whom? Technical member. Next, tenure and salary. Salaries don't read, unnecessary point. Tenure, 5 years. Reappointment is possible, maximum 70 years. Sebi 65, this is 70. Next, procedure. Whenever matter went to SAT, we need not directly go in person. We can either go in person or authorize a CA, CS, CMA or legal practitioners to present the case. That means already in Companies Act we read this. Limitation Act will apply. Only within the period of limitation you need to apply. And all the members, presiding officer, members, staff, etc. will be the public servants. Already we have decided this in Companies Act. Civil court not to have jurisdiction. This also we read in NCLT topic in Companies Act. When NCLT is doing something, no city civil court should involve. Likewise, when SAT is doing something, civil court should not interfere. Next, appeal to SAT. Appeal to whom, sir? SAT. Now, before going into that, SAT is a civil court. Okay, same powers. Summoning and enforcing, examination or discovery and production, inspection, issuing commissions. But procedure you need to remember. Very, very important for the exams. Let us see. Appeal to SAT. Appeal by aggrieved party. Appeal by aggrieved party against whom? SEBI has given an order, hurt, go to SAT. AO has given a penalty, hurt, go to SAT. Insurance law, IRDA gave an order, hurt, go to SAT. Provident Fund, Pension Fund, Regulatory Development Authority of India gave judgment against me, hurt, go to SAT. Therefore, person should have knowledge on insurance and pension. Okay, you are hurt by orders of some person. Where to go? Appeal to SAT. Appeal to SAT within how many days? 45 days from the date of receipt of copy of order. Can I extend by another 45 days? There is sufficient cause. SAT will give a decision. Yes, it will give a decision by giving opportunity of being heard. Dispose the case within a period of 6 months. Can I make an appeal again? Yes, within 60 days you can make an appeal to Supreme Court on a question of law, not on a question of fact. I will put this chart. If you want, you can take a photo. Sir, up to here, everyone understood the concept clearly? Please, one message. Everyone in the class, up to here, everyone understood the concept clearly? Okay then. Thank you. Next. So, vacancies and termination, resignation, removal, lastly special courts, one concept will be there. With that, SEBI will be over, sir. 10 minutes will complete SEBI. Later we will go to arbitration and conciliation. Okay, now vacancies and termination. First let us see. Filling up of vacancies. Vacancy can be of 2-3 types. Here see now. Temporary absence in the office of a PO or any member. CG shall appoint another person to fill the vacancy. Okay. The proceedings may be continued before the SAT from the stage at which the vacancy is filled. Main concept is, if there is a temporary absence caused, CG will fill that vacancy till that person comes. Okay. Permanent, death, resignation, etc. Senior most judicial member of SAT shall act as a presiding officer until new person comes. Here CG will appoint. Here automatically senior most judicial member of SAT will come and sit there. Next, resignation and removal. Resignation and removal. Okay. Whose resignation is covered? Presiding, technical, judicial, or judicial and technical. Writing law, you need to give resignation, address it to CG. Date of resignation taking effect. Very important question. When my resignation will take effect? That today, if you give notice of resignation, today it will not take effect. 3 months from the date on which you have given, or we appoint another person in your place, or your term may completed, whichever is earliest. Whichever is earliest. I will give an example you can understand. I was appointed 5 years back. My tenure is going to get completed on 30th October 2021. This is called as expiry of the term. I gave notice of resignation on 24/10 today. 3 months, November, December, January. 23rd January 2022. This is 3 months from the date of notice of resignation. Next one. Or we appointed some person. We appointed some person on 10th April 2022. Successor appointment. Whichever is earlier, happening first. Whichever is happening first, your tenure completed on 30th May. Even though you don't give resignation, that will happen. Okay. Let's change the numbers now. This is the first example. No sir, this is 30/10/2022. Now what will happen? 3 months will come first. This is the date. No sir, and again let us change the example. 10/1/22 itself they appointed, sir. Then this will be the date on which you have to exit, whichever is earliest. Okay, so date of resignation taking effect. Grounds of removal, same ground, sir. This is the concept. Special courts. Whenever offenses are committed, special court will come. That means whenever shall be punishable is used, special court will come. It will impose a fine, it will impose imprisonment. This is what happening. Main concepts I will cover: punishments, etc., numbers, etc. You remember. Mainly cognizance of offenses. Cognizance of offenses. First, composition means what? Composition is a concept of conversion of fine or imprisonment or both into a lump sum fee. Into a lump sum fee is called as a compounding, also called as a composition. I repeat, composition is a concept of conversion of fine or imprisonment or both into a lump sum fee is called as a composition, also called as a compounding. Okay, which offenses are compoundable? See here, 3 things are only compoundable. That means fine only, fine or imprisonment or both. Only these 3 are compoundable. Remaining conversion also not possible. You have to enjoy imprisonment. If it is a fine and imprisonment or imprisonment only, not compoundable. Compounding authorities, SAT or a special court will do the compounding. Compounding may apply even before or after the proceedings. CRPC will apply. That's a simple point. Next, Companies Act, special court will take your complaint, but who has to make an application? Who has to make a complaint? Either ROC or shareholder or a member or person is authorized by central government. Like that under Sebi, if any offense committed, who should file a complaint before special court? For special court to accept your complaint, Sebi should make a complaint. Who should? Sebi. Next, establishment of special court. Who will establish? CG, for purpose of speedy trial of offences. Same sir, Companies Act. Who will be there? Same concept. A single judge will be there. Okay, appeals and revisions, CRPC will apply. I told you very clearly when Companies Act was dealt, our acts will tell only the end result of punishment. What, how to file FIR, charge sheet, bail petitions, CRPC. Therefore, CRPC will apply and appeals revisions will be as per CRPC. Okay, so separately we will not establish special court. Special court shall be deemed to be the sessions court, and their company prosecutor will be there. Here just he will use the word person. Person conducting prosecution shall be deemed to be public prosecutor. Okay, contravention by companies, FCRA section number 39. Same concept will apply even here. When we come to FCRA, we will anyway discuss about that. So this is a recovery concept. This is the recovery concept. If 3 things are not paid properly, if 3 things, technically 4, we can club into 3. What are the 4? Let us see. Penalty was levied under the act, you are not paying properly. Refunds are there, you are not paying properly. Disgorgement, recovery is there, you are not paying properly. Fees you have to pay, you are not paying properly. Fail to pay penalty, refunds, disgorgement to fees to Sebi, you are not paying. Recovery officer will be appointed to recover that money. How to recover? 5 modes of recovery are there. Attach mobile property, attach bank accounts, attach immovable property, arrest him and appoint a manager to manage these immobile and mobile properties. This is just a notes you read later. So recovery officer can seek the permission of local district administration, means local IAS officer's permission he can take for orders. Mainly you need to remember 2 things here: grounds of recovery and modes of recovery. Penalty failure, refund failure, disgorgement failure, fees failure, mobile, immobile, bank account, arrest, management of assets that are attached. That's all, sir. With this, we have completed the chapter called as Sebi. So many persons are asking for so many days about Sebi. Exactly 2 hours it has taken to complete a big area called as Sebi. Okay. Sir, everyone, put a message, understood the concepts very clearly. We will take a short break and we will start with Arbitration and Conciliation Act. So completed, right? Let's take a short break and come. Let's take a short break and come. We will be starting with Arbitration and Conciliation Act. Very fast, we will be closing that chapter as well. What is the name of the chapter we are going to start? Arbitration and Conciliation Act. Where it is? Oh, last one. So take a break and come. It's 6:40 now. 7:05 we will start exactly. Aya PFA accounts evarayya nuvu indani oke message pedutunnao serious fraud investigation office. I will tell, or you read yourself. If you have a doubt, put in a Telegram channel. That's not so difficult. Serious fraud investigation office ademanta rocket science involve avula, normal special courts concept only. You read, and if you have any doubts, you put on the channel. If time permits, I will only discuss about that also. Anyway, so please take a break and come soon. 7:05 we will again revisit to the concept. Okay. So let us start with the next topic, Arbitration and the Conciliation Act 1996. So the next concept is the Arbitration and the Conciliation Act 1996. So this is the topic. So Arbitration Conciliation Act, what is the topic and what are all the concepts that will be covered here? So let us see at a glance first. Need for this chapter, if you understand, we can complete off very easily. So the concept depends on how good we are in the basics with regard to arbitration. See here, arbitration is a judiciary related concept. Judiciary is of two types, civil judiciary, criminal judiciary. Two types of judiciaries will be there. One is a civil, another one is a criminal. Civil judiciary will be having two types. Criminal judiciary. Okay. So civil judiciary will be of two types. First one, internal judiciary, external judiciary. Criminal judiciary also internal judiciary, external judiciary. Internal judiciary means we already discussed when we are discussing about the Companies Act. Within the Companies Act, civil authorities will be formed, that we call as internal judiciary. External means Supreme Court, High Court concepts. Okay. Same way the criminal judiciary will also work. When it comes to civil judiciary, a third branch is also opened in the year 1996. That concept is called as a private judiciary, which is called as a arbitration and conciliation. First point number one. Private judiciary, it's not internal, it's not external, it's a private judiciary. That means private judiciary means at the autonomy of the parties we can do. So that's called as a private judiciary. So private judiciary concept can work. Okay. So listen carefully. So the judiciary will be of two types, civil and criminal. Internal, external, and internal and external. Here also internal and external. When it comes to civil cases, private judiciary was given. When private judiciary concept has come, the legal mechanism is sent to background. Okay. What do you mean by that? Generally in a normal legal circumstance, there will be a hierarchy. Go to this authority number 1. After that come to authority 2. Light off chesi light. My face okay. So see here, when it comes to civil judiciary, there will be a hierarchy always. First one will be one authority. You lost, go to this. Lost, go to this. What are the powers of first authority, second authority, third authority? All these things will be clearly said in the act itself. But when it comes to the private judiciary, no such concept. Private judiciary, when we call, everything depends on agreement between two parties. That means judiciary will be as per your agreement, not as per any law. How that agreements should be was said in the Arbitration Conciliation Act. I think you can understand and correlate the concept now. Generally, Sebi, if you take SAT is a judiciary authority, adjudicating authority is a judiciary authority. What are the powers, what are the duties? All these things are said in the Sebi Act itself. Arbitration Conciliation Act, rights are not given, powers are not given. Who has to decide? Agreement has to decide. Therefore, the agreement is the most important element in arbitration. Okay. Arbitration is working as per the agreements you draft. That means generally court is something which is a established authority to render the law judgment established by the government. But private judiciary, it is run on a private agreements basis. So this is the first logic we need to understand. Let's have a look. Basics. Preamble to the act. An act to consolidate and amend the law relating to domestic arbitration within India, international commercial arbitration outside India, enforcement of foreign arbitral awards. Awards does not mean Nandi Award, Oscar Award, Dada Saheb Phalke Award. Award represents a final outcome. Final judgment is called as an award. Okay. So, domestic within India, international commercial arbitration outside India. Sir, why that is involved? Listen carefully. One person is in India. Another person is in USA. This person sold goods. This person has to pay the money. Dispute started between both of them. How can the dispute can be? Indian person can tell that you are not paying properly. Foreign person will tell that quality is not good, therefore I don't pay. Now the dispute is not between two persons within India. Dispute is between one person in India and another person outside India. Now which court I need to file a complaint? If you file a complaint in Bombay High Court, let's say he's in Bombay, in Mumbai, Indian person, that person will come to Mumbai. Or if you file a complaint in California House of Lords, then you will go to California every day. Or whenever hearing comes in a month. Impossible. Whenever the court that is involved is two different countries are involved in the court judgment, then going into any one court is impossible. Various problems will come which we can't even anticipate. In such cases, there should be a platform where judgments has to be rendered. Therefore, the concept of arbitration has come. It's a private judicial system. Okay. Rather than Indian coming to USA, USA coming to India, we do one thing. Indian person will appoint one arbitrator and USA person will appoint A2 as an arbitrator. A1 and A2 will meet in Dubai, common place. They will have a discussions with that, evidences will be collected. Now everything is online also. So after that they will render a judgment. How it will happen we will see in the chapter now. But this is how it apply. This is called as an international commercial arbitration. Next. Short title, Arbitration Conciliation Act, whole of India. Next one, definitions. Sir, key topics only let us cover. Let's not waste time in reading so many unnecessary points here. Arbitration means arbitration whether or not administered by permanent arbitral institution. Arbitration means it can be either by a normal arbitral tribunal or a permanent arbitral tribunal institution. What is that we can see? Arbitral award includes an interim award. Means what? It's a final judgment. Also includes, for example, one particular case involve various issues. On various small issues they will render judgment. Totally this is the issue. In this there are subparts. Subparts also they will give judgments. That's called as an interim award. Arbitral tribunal, either one person or a panel of persons, group of persons can be there. Okay. Next, court. In case of international commercial arbitration, court represents a high court. Okay. Other than international, principal civil court, city civil court. This is called as a city civil court. Hyderabad civil court will be there, like that, civil court. Okay. Next, international commercial arbitration means arbitration relating to dispute, not offenses. No, for offenses you can't have arbitration. One person murdered another person, they want to settle the issue, both the settling parties will go to jail. Okay. Offenses can't be arbitrated. Only civil cases will be arbitration possibility is there. Arbitration relating to disputes arising out of legal relationship, whether contractual or not, whether at least one of the parties, where at least one of the parties is a foreign national or a body corporate incorporated outside India, or AOP or BOA use management is outside India, or a foreign government is involved. Mark this important, every chance is there to come in exam. Repetition once again. What is an international commercial arbitration? International commercial arbitration means dispute resolution arising out of a legal relationship illegality cannot be arbitrated, whether contractual or not, where at least one of the party, two parties are there na, in that one party should be either foreign national or body corporate incorporate outside India, or AOPBY where management is there outside India. Establishment may be in India but management outside India, or a foreign government is involved. In these cases, international commercial arbitration came into existence. Okay, this is the concept added by Arbitration and Conciliation Act in 1996. Arbitration and Conciliation Act is there even in 1910 also. Arbitration Act is there, but what is new? 1996 la international commercial arbitration was added into Arbitration and Conciliation Act. Why? 1999 la FEMA is anticipated to come. Okay, FEMA has to come. Before FEMA itself, FEMA means a foreign trade. So therefore, when FEMA is drafted, they started drafting that in 1994 when PV Narasimha Rao is the Prime Minister. They started writing. When BJP is in the ruling, they brought that act actively. They presented before the parliament. That person, when he was a PM, PV, he also brought another act. FEMA will come, very good. But if disputes in FEMA will come, who will treat exports and imports law problems? Therefore, with a vision, he also brought an act called as Arbitration Act. So Arbitration Act was first came after he becoming ex-Prime Minister. Next, BJP government has taken the authority. They brought this act called as a FEMA. So for FEMA, this act has come. Sir, if dispute comes, arbitration, you said. Other than arbitration, is there a chance? Other than arbitration, is there a chance? We are telling that one person is outside and one person is in India. Three chances are there totally. Chance number one, that person has to come to India, this person has to go outside, which is very much a practically impossibility. Second thing is arbitration. What is the third thing that is possible? No, it's not mediation, it's not conciliation. Sir, mediation, conciliation, negotiation, persuasion, all these things are within this concept only. So do you know what is authority? That was included first in paper 6D. That's why after they deleted that. World Trade Organization, there you can file a complaint. WTO. So World Trade Organization, you can file a complaint. So World Trade, name itself is telling World Trade. So one country with another country, na WTO, World Trade Organization, you can file a complaint. Okay. So World Trade Organization, you can file a complaint and you can register your complaint. They will look after. That's an international court. But cost will be involved because World Trade Organization, eminent persons will come and render the judgments. So a lot of cost will be involved. Administrative expenses will be there. So if you couldn't bear all those things, arbitration is the cheapest procedure. Okay. So this is the point. Next issue. Next one. Features of arbitration. Okay, features of what, sir? Arbitration. First thing, arbitration will be first starting with an agreement because it's a private judicial system. Who should be the judge? You should decide. When you will start the proceeding, you should decide. When we should meet, you should decide. Place, you should decide. Venue, you will decide. Seat, you will decide. Everything at the decision of the parties. Okay, therefore it's a private judiciary. Arbitration agreement. Agreement by the parties to submit arbitration of certain disputes which have arisen or which may arise. What do you mean by this? You can go for arbitration after dispute or before the dispute as well. In respect of a defined legal relationship whether contractual or not. Sir, what do you mean by defined legal relationship? Means first agreement you are entering means on what you are entering. See here, X, Y. X said that I will give you 1 kg of heroin and cocaine. You should sell to Mr. Z. X said to Y. X entered into agreement with Y to sell these goods to Z. Y hasn't sold 1 kg, he sold only 750 grams. Aggrieved by that, X want to take this dispute towards an arbitration panel. Possible or not possible? Because there is no legal relationship that is existed. It's not defined. You can't define this legal relation now. That's the point. Now, what is this concept of whether contractual or not? There the question will arise. What do you mean by contractual or not? Question will arise or not. What is this contractual or not? Listen. There are 2 types of civil issues, sir. Civil issues are of 2 types. Contractual civil cases, tort based civil cases. Tort based civil cases. It's not said in institute study material. LLB law we will learn about this. Tort based civil cases will be there. What are torts? Law of torts is a separate concept in LLB. Law of tort. Tort means some unrelated person is there. For him you caused a damage. It's called as a tort. Tort means any kind of damage you cause to another party. Contract law you will not create a damage. Without a contract you make a damage to a person. I will give classic example to this. X is walking on the road, Y is going by a car. He hit him, broken the legs of the pedestrian, whatever the person you call. Okay, one pedestrian is there, car hit him and he broken his leg and went into hospital. He said that I will go to police station. He said that please I am not drunk on that day, but still by oversight or something I hit you. That's my mistake. Let's go for arbitration. There is no contract here, but there is a legal relationship. What is the legality here? I hit you. I am agreeing for that. Okay, I am not doing any offense here. Offense is always illegal. This is a civil situation here, because it's not a planned brutal murder that is committed. I hit you in the road by oversight. It's a civil case. Now legality is involved here. Nothing illegal. No one said me to hit you. Okay, deliberately I didn't do that. Inadvertently some accident happened, small accident. Now there is no contract here, but still we go for arbitration. That's why he said whether contractual or not. Okay, mandatory consent of the parties is required. No court, only arbitration. Consent should be contained within the arbitration agreement. That means both the parties should give their consent in the arbitration agreement itself. Okay, it is okay for me, it is okay for me. Consent should be given. Consent. Court will not involve, only arbitration. That means we will go to arbitration. We will not go to the court. You should clearly tell. Just by writing, we will not go to court in case of dispute. Will not make that you will go to arbitration. No. You should clearly tell that we will go only to arbitration and not to the court. You should clearly mention in the agreement. Next, arbitrator. Next feature, arbitrator, also called as arbitral tribunal. He is a neutral, impartial party and not to favor any party. He is similar to a judge of a court. Seat of arbitration. Seat of arbitration. Sir, what is called as a seat of arbitration? That means, listen carefully, this is very important, sir. There are 2 words, seat versus venue. Very, very important 2 terms. Confusion created because of these 2 terms. Seat versus venue. What is a seat? What is a venue? Seat means which law the arbitrator is going to apply while dealing with the dispute. Venue means the place where they meet. India venue, Singapore venue, Andhra Pradesh venue, Hyderabad venue, SR Nagar venue. It's not a seat. Now listen. CRPC, a CPC, seat. Okay. Civil Procedure Code of England, seat. That means try to understand clearly which law you are going to apply between both of them. That's called as a legal system which would supervise. Okay. Next. Seat, you have to decide clearly in the arbitration agreement. Party autonomy. Generally, judge you will not choose. Some judge will come and render judgment, but in arbitration, you have a freedom to choose which law to apply. You can choose. Okay, venue you can choose. Arbitrator also you can choose. Okay, seat you can choose which law. Venue you can choose. Judge you can choose. So then I will choose my brother. First person is that person should be impartial, not dependent on you, or you should have a complete independence. Okay, so finality of outcome. Generally, Companies Act, if you take ROC, NCLT, NCLAT, Supreme Court. ROC gave a judgment, I was hurt, NCLT, hurt, NCLAT, next Supreme Court. Hierarchy is there. Hierarchy is there. But in arbitration, here if you lost, appellate tribunal will not be there. Arbitration, it closes. So judgment rendered shall be final and no appeal against it. But you can make appeal to court only in one case. If that person is independent or impartial arbitrator, then you can do. Confidentiality. Everything deliberations made, because judge na anyway he will keep everything confidential. It's a court rule, court culture, but it is private. Therefore, he may blackmail you after the case. Therefore, everything must be kept private. Only to the parties it should know, arbitrator and parties. Prohibition on sharing information with others. Arbitral award, it's a decision given by the arbitrator. So please see this screen. If you want, you can take a snap. 30 seconds time for you. Make a fast, quick revision. Okay, completed. Next. So see here, the next one. Arbitration agreement. Sir, already we discussed. We said that arbitration, one of the feature is arbitration agreement. Now we are going to paraphrase that. Go deep into that analysis of arbitration agreement. Let's go very fast. Please see here. Details of an arbitration agreement. Meaning, agreement by the parties to submit to arbitration of certain disputes which have arisen or may arise in a legal. All these things, whatever we have read already. Forms of arbitration. Two options are there. Arbitration clause in a contract. Maybe separate agreement. Sir, what does it mean? I didn't understand. Okay, see here. You and me are entering into buy and sell contract. I am selling something, you are buying something. Okay, there is an agreement between us. In the contract document itself, clause is there, arbitration clause. There is a 60 pages contract or an agreement between you and me. In that 60 pages, the 36th page is talking about arbitration. If there is any dispute that comes in future between both of us, how to deal? We will not go to court, we will go to arbitration. Who will be the arbitrator? What is the procedure? Everything is there in page number 36 to page number 40. Arbitration details are given very, very clearly. Now listen to the concept. Now, contract 60th page, signature was made by both the parties. Once they sign on the 60th page, it is as good that they signed on each and every page from 1 to 59 as well. Therefore, again they need not sign on arbitration clause. Sometimes when they enter into contract, no arbitration clause is there, they want to add later. In that case, they have to sign separately. That's the idea. Maybe forming part of a separate form. Okay. Mode. Only in writing. Option 1. Documents must be signed, or you can exchange letters, telex, telegram. That is not there now. At that time the law was written. And option 3. Statement of claim made by one party and not denied by other. That means one person has written clearly that we are going to arbitration. We are going to arbitration. And I have given to another party. He also said that he has taken that acknowledgement received, but he didn't say any yes or no. That's all. Statement of claim. I am telling that I have a dispute with you. You have to pay this much. And that other person is silent. We will take that. It is not denied. Non-denial will be taken as a acceptance. Estoppel they call. Arbitration agreement through reference. There is a possibility of an arbitration coming into being through incorporation. Parties to an agreement could agree to arbitrate by referring to another contract containing an arbitration agreement. Okay, that means already these people are entering into continuous contracts in last 4 or 5 years. They said that our third contract, what is there, same thing will apply even here. Separately they need not again write. That will only will apply. Next, requirements of a valid arbitration agreement. So let's see very quickly. Let us complete this. See here, it should be in writing, no particular form or a template. Okay. Next, clarity in consent. The intention to go for arbitration must be clear. Consensus must be there. Okay. So it was repeated 2 times, only 1 time. The intention to go to a court, to go to an arbitration must be clear. Defined legal relationship. Only legality must be there. Illegal cannot be submitted for arbitration. Final and binding award. Once given, that is final. Appeals not possible unless independence is questionable. Specific words. You need not use the word arbitration, arbitrator, etc. That means you can tell like this. In case of any disputes between both of us in future, we will not submit to the court. We will go for artificial judiciary or alternate dispute resolution. Like that, if you write enough, that can be that can be arbitration, that can be conciliation, anything can happen. Okay. So such words are not necessary requirement. Next, dispute, either present or future dispute. Next, arbitratability means what? First, the disputes what you are submitted must be arbitrable. Disputes that law retains exclusivity for the court cannot be submitted for arbitration. Sir, example, criminal cases, matrimonial disputes, marriage, divorce cases will be there, na? Arbitration not possible. Batuku Jatka Bandi story gaadu idi. You cannot go like that. Okay, Batuku Jatka Bandi, inka evo unnaiga panikimali shows chala. Intadi, I didn't remember. Now in the YouTube channel people will put the names. I remember only one thing, Batuku Jatka Bandi, something is also there, na? I didn't remember exactly what the programs are. So when you take those programs, those are all artificial judiciaries only. They are alternate dispute resolution. Actually that program is artificial dispute creation, but intention is artificial dispute resolution. Okay, so matrimonial disputes will be there now, because law clearly said that if it is a matrimonial dispute, must and should to the court only they should go. In such case, lok adalat, all these things should not do overaction. Okay. Ratsabanda chusara adi manad form lo vachesadu Ratsabanda. Next, arbitrability completed. Signature. This is important, sir. Signature required or not required? Separately not required if it is contained in contract, but if it is not understood, if the arbitration agreement is contained in a contract, one time if you sign enough. When arbitration agreement is contained in correspondence or exchange or pleadings, separately you need not sign. In that anyway signature will be there. Next, litigation versus arbitration. Litigation means a court case. Okay, let us see. It takes place in a court chosen by parties. Verdict giver, court. Arbitrator is selected by the parties, that person will give. Procedure. What is the procedure? When to come to the court, when to go out of the court, contempt of court, to procedures, so summoning, enforcing, attendance of person, examination oath, all these things are decided by the rules of court. In India it would be governed by code of civil procedure and rules, but here flexibility to choose the procedures. Procedure also you have a flexibility to choose. Open versus close ended. Means what? The proceedings are generally open to public. Civil court anyone can see what is happening. So little privacy and confidentiality. But in case of arbitration, confidentiality is one of the most important characters of arbitration. Okay. In other words, apart from the parties, no other person is permitted to participate in arbitral proceedings. Appeals. Numerous appeals are possible. On very limited grounds, appeal is possible. Enforcement of foreign judgments. Okay, it is difficult here, but it is easy to bring foreign nationals, foreign companies, or any other foreign government. It is easy. Or AOP BOI, where the central control is there with the foreign person, then also. Next. Arbitrator or arbitral tribunal. What are his duties and liabilities? Let us see. First thing, he should not commit any delay. Delay does not mean in 5 days complete the judgment, not like that. Unnecessary delay should be avoided. That does not mean that he should be completing fastly whatever judgment you want you give. Not that. 3 points are there. Expeditiously possible. Expeditious means fast and beneficial. Arbitrator has to ensure that all legal requirements are met. What are legal requirements? Contained in agreement. Next, longer proceedings would mean more cost to the parties. Cost will be involved and we have to pay to the arbitrator. Impartial. Impartial means what? He should not favor any of the party. Okay. A biased outcome is no outcome and would not be acceptable. Next, confidentiality. Whatever happens in arbitration remains in arbitration only. Means what? Only within that arbitration parties it should remain, not beyond others. That means it should not go to public. The requirement of confidentiality extend to all, including arbitral tribunal, who is under a duty not to divulge any information that comes to their knowledge during the process of arbitration. Not only to the parties, arbitrator also should not disclose information to anyone in the public. No unilateral communication means what? A, B are there. Two parties are there. Arbitrator is there standing in the middle. B has given some information relating to the dispute. He should pass to A. A has given some information. He should pass to B. That means A pass information, B pass information to A, but this was not passed to A. A gave information to arbitrator, but he didn't pass to B. This should not be happening. Only dual communication should happen. Any communication made on the case shall be communicated to all the entitled parties. Arbitral tribunal should ensure that all parties have copies of communication and document received from any party. Deliberation, judgment. Arbitral award must be in writing, signed by the members. Shall discuss all issues before award. That means before giving an outcome, arbitrator should clearly tell, on this issue you have won, on this issue you have won, and at the last you are the winning party or the losing party. Like that he should clearly tell. Okay. Sir, only one arbitrator can be there. You can have multiple arbitrators. Sir, listen carefully. Example also I will give. See here. A dispute with regard to purchase and sale contract happened between A and Co. A individual and a partnership. Dispute happened, matter went to the arbitration. Now, what law will be involved here? Simply to tell, Contract Act, Sale of Goods Act, Partnership Act, more than anything, the Civil Procedure Code, 4 or 5 laws will be involved in one particular case. I can appoint arbitrators from each and every wing. One arbitrator is having fantastic knowledge on Contract Act. Mr. A I will appoint. B for sale of goods. C for partnership. D for CPC. Like that I can appoint each and every arbitrator for each and every small issue within the dispute case. So, cost if you are ready to incur, you can have. In case of arbitral tribunal with more than one arbitrator, decision of the arbitral tribunal shall be made by majority of all its members. So, this is the duties and liabilities of arbitrator. So, not so great. Everyone understood the concept clearly up to here. Everyone on live understood the concept up to here. Duties and liabilities of the arbitrator. Everyone. Everyone understood the concept up to here. So, a very small chapter. I will complete very fast. So, small issues will be there. That's all. Not so great. Okay. Next issue. Arbitrator or arbitral tribunal. Let's see what it is. See here. What is an arbitrator or arbitral tribunal? Nature. Performs the functions of a judge. What judge will do? He will do the same thing. Arbitral tribunal is not a court. It's not a court. It is something similar to court on a private basis. Who can be arbitrator? Any person capable of contracting. That means should not be a minor, should not be unsound, insolvent like that. Under Contract Act, who is capacitated to enter into contract? Some persons will be there. Those all can become arbitrator. But how good person you choose, that good will be the finality of outcome. Okay, other party is there. He appointed Mr. B as an arbitrator. A, B, two parties are there. Okay, A appointed Mr. C, B appointed Mr. D. C is impartial, everything is there, but he is a newly qualified LLB student. D is having 25 years of rich experience in law. Obviously, D's arguments will be better than C's argument generally. Okay, so therefore, if you put C as an arbitrator, no one will tell, oh, C is having lesser experience, he cannot become judge. It is your wish. Your person has to speak better or not during the argument, that is your wish. Therefore, he is competent to contract. Yes, you appoint him, no problem. Qualifications, education, nothing is there. Next issue. So, appointment. Appointment works on the principle of party autonomy. Means what? Whoever you want, you appoint. I have freedom to choose 4 things. Procedure, when to come, where to come, all these things. Arbitrator, who has to come, venue, where to go and listen to the argument, seat, which law to apply, subjected to certain limitations, you can do. Next, procedure for appointment. How to appoint an arbitrator? 3 types will be there. Parties can jointly appoint one arbitrator. Second one, each party will appoint one. Those 2 will appoint a third one. He will be neutral party. Or appointment will be made directly by unrelated person or an institution. President of ICAI, Chambers of Commerce in India. These persons can also become arbitrators. Next, number of arbitrators. There can be 1 or more arbitrators, but more arbitrators will result in greater discussion and improves the quality of awards. But along with that, cost, time also will involve. Next, requirements of arbitrator or arbitral tribunal. Okay, see here, same concepts are again. Headings you see. Nationality. International commercial arbitration, we said. Arbitrator from USA will come. You cannot ask him, are you Indian national? Why I will be Indian national? Therefore, he could be of any nationality. This will be more evident in international commercial arbitration. Capable of contracting. Okay, read only the headings, sir. Lack of bias. Bias should not be there. He should be independent. That means my employer, my officer, or a person working below me, you should not employ them as arbitrator. Impartiality. He should not favor one party and defavor another person. He should be neutral and impartial towards everyone. Next. Termination, removal, substitution of arbitral tribunal. See here. Termination. This is important question, sir. Examination or 2-3 times this was tested already. So, termination, removal or substitution of arbitral tribunal. We will be having 4 kinds of exits of arbitration. Let us see what they are. Voluntary exit. Voluntarily parties can exit. How? See here. Arbitrator may, for various reasons, decide to no longer act as an arbitrator. Something similar to that of resignation in a directors. It is important to remember that being a private consent-based arrangement, an individual cannot be forced against their will to act or continue acting as an arbitrator. So, main point is resign and go away voluntarily. Second one, he was removed. At times, all parties involved, not just majority, all the parties involved may decide to no longer continue with a particular arbitrator. Next. Okay, next one. Arbitrator only unable to continue. Arbitrator unable to continue. Okay, this we will see at the last. See, when arbitration process comes to an end. Let us read. Once you understand that, you can really link this. First, see the decision of court. By first one we completed voluntary exit. removal. Third one, operation of law. Fourth one, decision of the court. Let's see that first. Court may remove due to biased approach of arbitrator. 1 point. Okay. Next, decision of the court. Steps in challenging the integrity. That means we can challenge that this person is not having confidentiality or integrity, or he is not unbiased. Like that we can. Challenge must be raised before arbitral tribunal itself. And step 2, then appear before the district court for domestic arbitration, high court for international commercial arbitration. Challenge that person is not impartial, that person is not unbiased, that person is not independent. Challenge, win the case. In that case, okay. Next, appointment post termination. Follow original method of appointment. If step 1 fails, approach Supreme Court in case of international commercial arbitration, high court in case of a domestic arbitration. This is for appointment post the termination. Means what? Let us understand clearly. See here, sir. This topic is termination, removal, substitution of arbitral tribunal. Okay. See here. First one is a voluntary exit. If you want to go out, you go out voluntarily. Second one, if you want to, if you are removed, all times, anytime, all the parties can decide to remove an arbitrator. You will remove. This one we will see. Decision of the court can also remove an arbitrator. In which case, if he is biased, remove him. Sir, he is not having integrity, sir. That means he is changing every day. If we pay salary or a remuneration to him, that day he is giving properly, or else he is not giving. He is not working properly. In that case, challenge him. Where to challenge? International commercial arbitration, high court, or else district court, you will make a complaint. You will make a complaint. Sir, I am not having that, or what to say, appointment post termination. One person is terminated. Appointment post means after the termination. Means what? I appointed a person, I want to remove him. Again, I want to make an appointment. Okay. Now, follow the original method of appointment. How you appointed through arbitration agreement, appoint. If you want to remove that fellow as well, now not just district court to high court, directly it will go to the Supreme Court in case of international commercial arbitration, high court in case of a domestic arbitration. That means second time also, if you want to remove, follow the appointment, follow original method. But for removal, you should go to Supreme Court in case of ICAI, you should go to high court in case of DA. So up to here, I am putting the chart here. If you want, you can take a snap. Okay. So see here, first one, voluntary exit, removal, court. Court, if you want, I will repeat, unbiased he should be. If he is biased, remove him. Court will remove. You are challenging him on the terms of independence, etc. Yes, challenge them. Where? High court for ICA, district court for DA. No, sir, I am appointing post the termination. One person is terminated, again I am making appointment. That person also you want to remove. Follow the original method. Appointment, you follow original method. But if you want to remove, okay, if you could not do that, if the step one also failed, you could not do like that. In such case, second time directly go to the Supreme Court in case of ICA, and district court in case of a DA. Sorry, high court in case of DA. So, and this is the concept with regard to this particular termination. One point is still there, operation of law. By operation of law also you can have a termination of arbitrator. Arbitrator unable to continue. He is de jure unable to perform his functions. What is de jure? De jure means as per law. Jure is a word in Latin derived from the word jury. Jury has again came to another English word called as judiciary. Okay, jure, de jure means through judiciary. Law prohibited him not to continue. Okay, he became unsound, like that. If you become law will prohibit you to continue. Next, de facto unable to perform his duties. What do you mean by this? De facto, law is not prohibiting him, but he is unable to continue for his personal reasons. Health is not permitting me to continue. In fact, I am terminating. Law didn't ask me to terminate. In fact, I terminating, but law didn't tell me to terminate. He has any other reason, he has for other reason fails to act without undue delay. In such cases, in case of controversy and appealability of hearing out, you shall resort to the court. Generally, no one will put a contradiction on this. So, as per law, you are unable to continue. Go out. Or de facto unable to continue. By fact, I don't want to continue, but by law, I can continue. But I don't want to continue. My health is not permitting me. First one is a voluntary exit. Decides no longer to act as an arbitrator for them. Here, I can't act as arbitrator to anyone. My health is not permitting me. That is only for one case. This is generally. Okay. Any other reason, he is delaying the case. Remove. So these are the cases in which this can happen. When arbitration process ends. Okay. Arbitration process ends. These are the sections governing that 29A, 32 and 25. Anyway, we'll come to that. So this is a basic idea behind termination removal. Arbitral award, the final outcome or a judgment. Meaning, arbitral award is similar to the judgment given by a court. In other words, arbitral agreement is given by an arbitral tribunal as a decision on various issues in a matter which the parties has placed before the tribunal. That means arbitral award is a judgment. On what basis? On the basis of facts given by both the parties. As per section 2(1), arbitral award includes a interim award. We already read. Challenging the arbitral award, mark it very, very important for the exam. Who can challenge? Party to an arbitration agreement? Yes. Not being a party? No. Outsiders can't challenge. That's the idea. That means other lawyer, etc. cannot do that. Only parties into the case. Challenge before whom? Domestic district court and high court. International only high court. Next. Limitation period. Within what time you have to file a challenge case? Time limit. Within 3 months from the date on which award is received by the party. Maximum extension by 30 days. The award was rendered on 1st January 2017. Therefore, award can be challenged by 31st March. 3 months. Jan, February, March 31st. This date could be extended by another 30 days. 30 days. By on application to the court, that is till 30th April 2017. There can be no further extension. Next. Types of arbitral award. Final award. This is in accordance with the requirements of a law. Finally, this is the judgment. Finally adjudicates on all the issues. Finally adjudicates. Interim awards. Till the final comes, any judgment will be given. That's called as a interim. Settlement award. Okay. Instead of going for adjudication, they will apply for a settlement. Settlement award is called as a conciliation. We will see that anyway separately. Let's read and leave now. During arbitration process, the parties may choose to settle. Means they will transfer the case to a conciliation instead of having adjudicated. Sir, what is the difference between adjudication and conciliation, or arbitration and conciliation? Arbitration is on win-lose concept, but conciliation win-win concept. That is a settlement, compromise. Win-lose means court law, what will happen? One person will win, one person will lose in a court case. Arbitration is similar to court adjudication. But conciliation is not a court adjudication. It is a settlement. So you can shift the matter from adjudication to a conciliation. In such case, the arbitrator could assist the parties in arriving at a settlement. If settlement is arrived at and arbitration has no objection, then the terms of settlement could be part of a award. Settle the issue. That means transfer of case from arbitration to conciliation. Additional award. Condition 1. Final award has been rendered. Okay. Later it is found that certain claims were not resolved. That means a big dispute came. In that dispute there are sub-disputes. They came to know that judgment was given on a finality on the basis of 1, 2 and 5. But 3 and 4 issues they didn't consider. Parties can request arbitral tribunal to make an additional award covering the issues that had been left out. Such request shall be made within 30 days from the date of receipt of final award. Then they will add to that and then they will give another judgment. This is all about types of arbitral awards. Requirements of arbitral award. First, majority should decide. Writing dated and signed by the majority. Reasoned awards, just like that. Since it is a private argument or a private judgment, you should not just tell you win, you lost. Reasoning should be there. Okay, reasoning should be there. It is mandatory that an award should be reasoned. Failure to state the reasons would make the award invalid. Okay. In the arbitration agreement itself, they have written that award don't require any reasons. Then exception. Award should not be vague. Vague means confused. If you read, you are not understanding who won, who lost. So see here, do's. It should be certain and clearly note which party has to do what. That means this party has won the case, this party lost the case, therefore you should supply goods to him. Clearly you need to tell like that. Do's. Don'ts should not be like a recommendation. You may do, you may not do. Like that it should not be. You should do. It's not like a recommendation. It should be a commandment. It is sasanalla undali gaani optional undakodu. Must not be tentative, not temporary. It should be a permanent solution. Must not leave a party with an option to either to perform or not. One person, you may not, like that it should not be. Award should be capable of being performed. It should be realistic and not impossible. Next, conciliation. Everything is same, so let's not waste the time. Voluntarily you will choose the parties, everything. Assisted procedure, instead of arbitrator, conciliator will be there. Finality, it's a final thing, no appeal possible. Confidentiality, everything is same. Added point is non-adversarial. What is non-adversarial? Court judgment is always adversarial judgment. What do you mean by adversarial judgment? One will be favored, another will be adverse. Judgment in favor of one, adverse to another. But in conciliation, adverse concept will not come. Okay. Like in a court, here parties don't compete each other to prove themselves as correct and others as wrong. Nuvu correct and wrong ani vaadinchukodam kaadu conciliation. It focuses on providing a solution. Instead of focusing on win-lose, it is a concentration on win-win. Both of us let us win. Parties don't behave as opposites. Okay. They behave like peers and they will decide about the issue. That's all. Other issues, the same, sir. Everything, whatever you read, number of conciliators, everything is same. Just we need to read the differences between mediation and conciliation as a last point. Role. Mediator plays mediation and conciliation. Mediation plays a facilitative role and attempts to guide the parties towards a solution. Thus, solution should come from parties themselves. Conciliator plays a proactive role. He acts as a facilitator, evaluator, and intervener. In other words, he can also, along with the parties, suggest solutions. Mediation, one person will sit and tell, both the parties come to a conclusion. Conciliator will tell what both the parties has to do. Outcome. It is an agreement between the parties. It is a settlement agreement. Let's settle. This is an agreement. Means what? Subjected to changes. But this is settlement. Settle the dispute. Enforceability. The agreement reached by the parties in a contract is enforceable by law. The settlement agreement reached between the parties has the same status of arbitral award. In other words, it is executable as a decree in the civil court. Legislative governance, CPC will apply, arbitration conciliation will apply. Breach of agreement. Okay, normal breach of contract, what will happen in CPT or in the foundation level, what will happen? Breach of contract, vindictive damages, actual damages, remote damages, that will be there. Here, same thing. That means in breach of agreement, both consequences are same. These are all the main concepts that we need to learn in the area called as arbitration and conciliation. So since the concept is not so great concept involved, I went on very fast to complete this whole idea behind arbitration conciliation as a revision. Okay, so when we come normal into normal session, we can explain every word, every intention we can understand. On an overall basis for that 4 marks, this logic is enough and these charts are also enough. So more than this, not at all required. So here we completed this chapter also, and this chapter will be called the Arbitration and Conciliation Act. Okay, so this is the whole idea behind the Arbitration and Conciliation Act. So we completed the most important concepts for the exam. One is a Sebi, another one is an Arbitration and Conciliation Act, and this anyway not there in my channel. PMLA, FEMA already there in the channel. Okay, just amended also there, including the concepts of external commercial borrowings, imports, everything is already kept in the channel. So PMLA there, FEMA there. Okay, now we made Sebi LODR is already there. IBC and FCRA anyway I said we will do in 2 days time, we will do that. So all the lectures on economic laws, the revision part is already available on the channel. Okay, so if you want, you can revisit to that and you can complete off. My throat is not supporting me to continue. So here we end up with the session. Okay, next we have an obligation to come across the amendments in Insolvency Code. What are all the amendments that came? PPIRP, FCRL amendments. Amendments in FCRA, amendments in IBC. These are the 2 areas which we need to cover. Yes, we will be covering in 2 days. Wednesday and Thursday, or Thursday and Friday. Any 2 days, continuous 2 days I will take and I will complete. Now if you learn, 30 days you will retain in your brain. Okay, so fastly you can remember, you can write an exam if a question comes from that area. But 100% sure, amendments in FCRA, amendments in IBC will definitely come in examination. 8 marks will come definitely. Okay, we will be doing good thing and we will be doing a better understanding of those 2 amendment areas. Okay, so I am taking a leave. So I couldn't continue further because tomorrow session will get disturbed again. I have some classes. So hope everyone benefited out of the revision done on Sebi, especially the 8 marks or 10 marks area. Everyone understood the concept clearly? Everyone understood the concept clearly? Everyone completed? Understood the concept clearly? Okay then. So thank you. Sir, this is not a last live session, sir. I will be there with you till you write the exam, I said. The day of exam also, I will put a 4-hour session. Okay, day of exam, the before day. Quick revision, everything. I will be there till you go to the hall. Okay. So please, academic laws also, all the lectures will be available on the channel. You can visit. So please do subscribe to the channel such that it reach more number of people. Because 20 to 30% of the viewers have not subscribed to the channel as per the analytics given. So please subscribe to the channel. It reaches more. That's the only idea behind. Okay. So it reaches more number of people. So please share the channel details to your friends to subscribe. So please, if you really like the lecture, please kill that like button. So thank you very much. We'll meet again in the next session. Good night. Have a nice day.